and permission. So at least one. So contempt matters. Still number one. So Shiv Prasad Shanti order.
Appearing for the complainant. Lordship, may kindly peruse order dated 11th November 2024, my lords. There was a direction if they can file review, otherwise they have to comply with the order.
Notice returnable on.
Lords, notice has already been ordered. Yes, my lords. On
In fact, this is a case where the sale deed was to a particular extent. And that amount of land is not there. And it was wrongly mentioned in the sale deed, as in when the initial mutation was done. So we have filed our compliance, my lord, and the last time your lordship said, please keep the Tahsildar present. The Tahsildar is present. However, this is a case of impossibility of compliance because over here, the issue is, my lord, when the grant was done in the year 1993, along with the Sagoli cheat, a committee is formed to look into the grant. And when the committee looked into the grant, the available land at that point of time in 93 was only 1 acre, 26 kuntas.
The clarification from learned single.
My lord, we have asked, the process has been expedited.
Do it. February.
The dispensation of
So stated that-
Tahsildar's presence, my lord.
It was stated that that Tahsildar is personally present pursuant to the. Did we pass the order or orally?
yes, my lords.
Orally, it was just
It
mentioned
was
that
stated
if
that
you
the
haven't.
Tahsildar respondent here is personally present. Learned additional government advocate. Miss Shweta Krishnappa, our prayer for time to submit that. Though it is a case of impossibility of performance. He will seek necessary clarification. Learned single.
Please, much obliged.
Put upon 19th. Put upon 19th February. With observation that if
Much obliged.
Lords, may I request for a date in January?
are shown, the respondent shall be liable to implement the order.
Lords, may I request for a date in the last week of January?
Last week of January. 28 Jan.
Much obliged.
This still number two. Mr. Sharath S. Gowda.
Lords,
The state in the matter.
may I request your lordship attention to the order passed on 12/11/2024, my lords, in the order sheet.
We have complied, may I just pass on this?
It's not compliance. It was only a indulgence shown by this honorable court. If they want to prefer an appeal, they have to deposit the amount. Your lordship may kindly peruse the order dated 12/11/2024.
The deemed regularization.
Deemed regularization matter. Your lordship observed that it is a case of audacity. They are issuing an endorsement contrary to the directions of this honorable court. They should have withdrawn the endorsement. Then if so advised, they should have chosen to file appeal and deposit the amount. Now they are just filing the appeal and depositing the amount. That is,
Then the only direction is to
Deposit.
calculate and deposit with the registry.
We have
the
deposited.
money.
We have deposited.
no, my lord, that is not, that was the direction of this honorable court, my lords. Your lordship may kindly see the order, my lords. Dated 12/11/2024. May I read it, my lords?
We have complied it, lords, ma'am, just produce
We
the
were
copy.
directed to deposit the amount and we have accordingly complied with the. amount.
Lords, if
For whom?
My lords, MCC, for the.
Mysore City Corporation.
Mysore City Corporation.
Lords, the order dated 12/11/2024, my lords. May I read it, my lords, for a moment? In the order sheet, my lords. These two writ petitions bearing 3461 of 2021 and 253 of 2021 came to be disposed of by the learned single judge by common order dated 6/4/2023. The order reads as under. The issue involved in these writ petition is with regard to consideration of the case of the petitioners under deemed regularization, and the same issue was dealt with by this court in WP 3672 of 2021 and connected writ petitions disposed of on 5/4/2023. In view of the matter, the contention raised by the learned counsel appearing for the petitioners is accepted in light of the observations made by this court in aforementioned petition.
Is there any need to read the whole order?
My lords, then my lords, para 3.1, my lords, the para 3.1, my lords, your lordship may. The directions in the said order dated 5/4/2023 to be applied to the case of the petitioner reads as under. Respondent authorities are directed. Then my lords, 3.2, as demonstrated by the learned advocate so and so, out of two petitions named Srimati Umadevi in WP 3461.
Appeal is filed or?
Yes, my lords, appeals are filed.
Lords. They have filed appeal
So the
and
right to prosecute the appeal and whatever result will be,
My lords,
they are, they
and-
will abide by.
your lordship observed that my lords, your lordship may kindly
So in
appreciate.
order to balance the things, we directed them to deposit.
My lords,
We have done it.
my lords, my lords, the directions of the learned single judge was to comply with the order as passed in 3672. Now 3672, they have complied, not only given the retiral benefits, also paying the pension amounts, my lords, and also considered them as deemed regularized. Now here, my lords, what they did, they issued an endorsement after filing of the contempt petition, saying that you are not entitled because you are appointed subsequent to 1986. Your lordships observed in that order dated 12/11/2024 that even though you have been appointed subsequent to 12/11/1986, you have been given the benefits of deemed regularization and extended benefits. Therefore, you cannot take a contrary stand. It is hit with Article 14 of the Constitution of India. And your lordship said even if they fail, at prima facie, there is no merits to file writ appeal. However, if they so choose,
We are not here to express anything on the writ appeal
please, my lords.
until we reconsider the writ appeal.
Please, my lords, your lordship may kindly fix a date in that writ appeal because of what has transpired.
An advocate for the petitioner.
At 2:30, my lords,
Attention of the court to the order passed on 12/11/24. Paragraph. In the said order, after considering the controversy and making prima facie observations, the respondents were directed to calculate the amount payable to the petitioner and deposit the same with the registry of this court. It was in the light of the fact that the respondents wanted to prefer an appeal against the order which is alleged for contempt of court to be subject matter of the present proceedings. Today, when the contempt proceedings came up for consideration, learned advocate Miss
Varshini Bhatt.
so and so appeared for number so and so, whereas learned advocate Mr. So and so
Bhanu Prakash.
appeared to jointly submit that the writ appeal is already filed and that the amount as per their calculation is deposited to the registry of this court. Full stop. It would be appropriate that the respondents are permitted to prosecute their writ appeal in accordance with law and on merits. Full stop. Therefore, the present proceedings are adjourned to February
lords,
25th.
well,
Great.
Before which date, it is expected that the respondent shall obtain appropriate orders in the writ process. The contempt proceedings may be postponed till then. To be listed on 20,
my lords, may I make this
to be
submission.
listed on 28th.
My lords, both contempt as well as the writ appeals on the same date, my lords. Can that indulge?
Yeah, who are we to list the writ appeal? It is not here. How do you say that it is before us? Until it is before us. So we have said that they will obtain appropriate orders before.
My lords, this amount which they have deposited,
Is that it is listed and
Yes, my lords.
whatever.
my lords, the amount which they have deposited before this honorable court.
What is that amount total?
15 lakhs and 11 lakhs, my lords.
And
Why? Two petitions?
two petitions. There are totally three
and-
petitions, my lords.
So you want to invest in the fixed deposit?
Any fixed deposit, my lord, at least it will fetch
Amount
interest.
which is deposited, which is stated to be approximately 15 lakhs. in
15 lakhs and 11 lakhs. my lords.
Give the figure.
My lords,
Producing the copy of the.
With the registry of this
Deposit.
court shall be invested in a fixed deposit by the registry in a nationalized bank. Cumulative
Any-
fixed de-
any
cumulative fixed deposit for initial period of 3 months, 6 months, 1 year.
3 months, 3 months.
3 months to be renewable, subject to further order of the court. The interests are accumulated and shall not be paid to the.
Lords, this order will be applicable insofar as serial number 2 and 3, my lords. In 2, there is another connected contempt petition, CCC 769 of 2024. There they are yet to deposit
Please.
the amount.
What happened, my lords, was serial number 2 and serial number 3, there was a direction which we have complied with. Serial number 2.1, that is contempt 769, was listed only last week for the first time, my lords. I have already instructed my officers to comply with them. With the next date of hearing, we'll ensure that the compliance is done and placed before my lords.
So this will be common order in 2, 2.3 and 3,
Please,
right?
please.
So, my lords, but in CCC 769 of 2024, they are yet to deposit the amount, my lords. They have not yet deposited.
As far as the contempt petition number 769/24 is concerned, learned advocate Mr. So-and-so stated that the directions are in the process of compliance and shall be complied with before the next day.
Please,
Correct?
please.
my lords,
Great, from
Is it correct? 2.1.
2.1.
yes, my lords. My lords, there, my lords, here, my lords, never, no doubt, my lords, they are having right to file writ appeal, my lords. But part of the very same order, they have complied, given retiral benefits, dispersed amount.
So that's a good argument in rate appeal.
Yes, my lord. Therefore, my lords, may request an indulgence that any shorter date and at 2:30, my lords. My lords, because they are, my lords, now, my lords, they are not getting pension, my lords. It has become very difficult for their survival. They have been thrown out unceremoniously on attaining superannuation. They have worked for more than 35 years. And Uma Devi, my lords, instead of actually reading the judgment of Uma Devi in letter and spirit, they are using it as a tool to take exploitative terms of employment, my lords. They take employment for 35 years. Thereafter, they deny, saying that in Uma Devi, there is no, in Uma Devi, the judgment has been laid on that there is no case of backdoor entry. But we are all working for, therefore, my lords.
This is good enough. Yes. Next.
Obliged.
Why do you retire? You are welcome.
I have filed wakalat on.
All those miscellaneous things on that day will they tell, not today. Please.
Seal number 4, Mr. Rajkumar MD.
For the complaint.
What is it?
Lordship,
Complaint?
there is a delay of some 24 days in filing the contempt, my lords.
What is it? Again,
Lordship, they have not complied, the BBMP officials have not complied the order of this learned single judge order. My lord.
My lord, I appear for the accused number 1 to 3, my lord.
so what is the status of compliance?
My lord, I need to seek instructions from my senior, my lord. Kindly give an adjournment.
Lordship, they are
17th
seniors.
January.
Lordship, kindly fix one date, Lordship.
17th January.
17th
17th January.
Obliged.
Seal number 5. Mr. Srinivas, party in person.
13%. My lord, I have filed a contempt of court petition for the non-implementation of order passed in WP 39573 of 2016. So order was passed on 11/7/2024, and they directed the BDA and society and
Is returnable on. Your appeal?
to within 3 months, but even after 6 months, they have not complied.
We are
with it.
issuing notice to the respondent, returnable on 6th February.
We are all senior citizens. One is 86 years old. I am 68. Another person is 76. Please provide us justice at the earliest. We have already spent 12 years of litigation in this matter, my lord.
So we are calling them to answer your case. 6th
Seal
February,
number 6, Mr. Somshekhar
6
Ayya.
February is too long, my lord.
that is.
Make a shorter date.
So in
Please.
this matter, I will not be able to take. There is no pro forma. Not so.
Just find out. Just next.
Seal number 6.
Who appealed? What is the problem?
My lord, now despite there being order, we have submitted representation, my lord. Even after, my lord, though the order was passed on 19/4/24, we have submitted representation way back in May 24 itself, my lord. The only till today, my lord, no steps have been taken to give effect to the, my lord. Since from 2004, my lord, we have been fighting for the allotment of sites, my lord, though they have identified way back in the year 2018, my lord. till today, my lord, they are not able to get the allotment of sites, though it is identified and by the concerned authorities and forwarded to the concerned authority for allotment of sites. Therefore, my lord, we have approached the Assam court. They have changed the list, my lord. The Assam court, my lord, cancelled that list and directed to redo the list by considering the earlier report submitted by them. Everything has been completed, my lord. The matter is still pending, my lord, since from 2018, my lord. Before that, my lord, for the more than 10 years, my lord, they have been fighting. My lord. Nomadic tribes, my lord.
So the title is incomplete.
Please, my lord, we have been submitting, we have submitted representation.
No, title of your contempt petition is not proper.
My lord, I will implead all the persons. Because my lord, organization is there, my lord, therefore, my lord.
They are the only necessary.
Please, please, I will file.
Whether who has made representation?
My lord, all of them must.
All of them.
All the petitioner number 1 to 59, my lord. Petitioner number 1, my lord.
One is association.
Assessment. And he is taken by interest in with regard to all these persons.
Correct your title and then,
Please, my lord, I will file.
so you withdraw this and file again.
Please, my lord, may permitted to withdraw and
Law and
to file.
Recruitment, so and so 6 points to withdraw the present contempt petition stating that the title is not perfect and there are certain technical aspects to be rectified. In that view, permission is granted, liberty reserved, full stop, liberty is reserved to institute fresh proceedings in accordance with law
Please, my lord.
and after correct
Please, my lord.
mentioning of title.
So 7, this urgent number 8. So Sharath is okay.
Appearing for complainant, your lordship. Complainant and accused are husband and wife, your lordship, where they have this minor child, your lordship. Minor child is US citizen, and there is a direction from the Honorable Learned Single Judge to give the consent for a renewal of passport, your lordship. Despite there are 3 directions, the accused has failed to give the consent for the renewal of passport.
Which is the direction to be complied with? Page
Page 15, your lordship.
page 15.
In relevant portion in page 16, it is submitted that the passport of daughter who is US citizen has already expired and it has to be renewed. Learned counsel for the father submits that if the passport is renewed, it is very likely that the girl is a US citizen and she will be taken out of country. Learned counsel for the mother submits that she will deposit her passport before the trial court. Considering the same, it is directed that the mother shall deposit the passport before trial court and father shall give consent for renewal of passport, your lordship. This is the first direction. We have submitted our passport before the trial court, your lordship. And on the next date, your lordship, that is in page 19.
19.
There's again, there was a direction. On the last occasion, an order was passed with regard to father consent for renewal of passport and visa of the child. Learned counsel for the
Notice
respondent.
returnable on 7th February.
Grateful.
This is number 9. So
Appear for
Sharath
the
is
complaint. The order of which disobedience is alleged. But the order of which disobedience is alleged is at annexure A, page 12, my lords. The relevant paragraph is para 4, page 14. The direction was to consider,
So fresh matter,
my lords,
fresh matter,
fresh matter.
notice returnable on 7th February.
Seal number 10 to Vasudevan C.
My lordship. And it's already almost it has complied. They have sent a notice to the complainant stating that they will provide the facility, that ECHS facility, that means for ex-serviceman contribute to health scheme facility to the complainant. They sent a letter. I'm producing that letter before this.
What is it? Extend the hospital and medical. What is non-compliance?
My lordship.
What is non-compliance?
It's the order of the Supreme Court to consider the complainant for ECHS facility. I mean, ex-serviceman health scheme facility.
Where is the Supreme Court order?
The page number 40.
14. 14. 1-4. 1-4 is now here a memo. Page 19 with Karnataka High Court.
May I read the order?
Where is that?
Please. That the complainant, Lord, was a storekeeper in General Reserve Engineering Force, which is under the Army Headquarters, my lord. Thereafter, my lord, by virtue of the order of the Honorable Kerala High Court, certain benefits, retirement benefits were given, my lord. So in the retirement benefits, my lord, canteen facilities were given and other benefits excluding the health benefits were not given. So therefore, the complaint preferred a petition before this honorable court, which came to be dismissed, and a writ appeal was filed. And the writ appeal, my lord, the direction was to give him the benefits of hospital and medical.
Page 30.
Please. Medical facilities, against which, my lord, the complaint preferred an apex court, preferred appeal to the apex court. Now, my lord, we have said that, my lord, we will comply the order, my lord. We have issued him a letter also for the compliance, my lord. I'll place it on record, my lord, with the memo.
Kindly,
Please.
We'll take
kindly make a note of this and dispose.
Lord, that the first letter is addressed to me, my lord. The letter behind it is, my lord, it is stated, my lord.
When the present contempt proceedings came up for consideration, learned additional advocate general, Ms. Shanti Bhushan, produced copy of communication dated 9th November, addressed to him by the administrative officer in charge, RLC Pune, in which it is stated that in this, it is stated with reference to the present contempt petition that orders which are brought under the contempt proceedings will be complied with, and the process for compliance is already underway. The order requires the authorities to extend the hospital facility to the petitioner, as well as medical facilities, hospital as well as medical facilities to the complainant. The aforesaid communication mentions that the department has already taken necessary steps to implement the court's order. Copy of this letter is given to learned advocate for the petitioner, Mr. So and so, who acknowledges the same and stands satisfied with the commitment expressed by the authorities about for compliance of the order. Full stop. Even he has filed paragraph, a memo dated 10/12/24 with reference to the same to state that the complainant, ex-serviceman, complainant who is an ex-serviceman is extended the benefit hospital. And that the order is compliant with, therefore. The grievance stands satisfied. Grievance is satisfied.
Satisfied.
Full stop. In the above view, nothing survives in the present petition. It is disposed of accordingly.
Great.
This is seal number 11. In the Iravati 14%.
What is it?
Learned advocate for BBMP further submits that the notice has challenged the order dated 28 to 22 issued under section 248(3) of the Act in WP 2627 of 24. It is submitted that learned single judge by order dated 20/11/24 has granted interim direction not to demolish the standing construction. In that view of the matter, the respondents are not in a position to demolish the building construction. Interim order is extracted. It is submitted that the complainant is party respondent in WP 2627 of 24. In the light of the above aspects, the order dated 28/2/22 marks substantial compliance of the order under contempt. It cannot be said that respondent has violated or in disobedience to the directions in the order. In contempt, the contempt petition would not survive for further consideration. The the contentions of the parties are left open. Parties will be abide by the outcome of writ petition.
My lord, I did not understand the last.
Since they have filed appeal,
Huh.
whatever the outcome of appeal will be there, the party will be abide by. For the present, no contempt survives. After the appeal decision is rendered, you can have your remedy.
My lord, can you give me at least 2-3 months hearing? Because if that doesn't happen, I have to again file
See
and.
that your appeal is disposed of early.
Yes, ma'am.
We have instructed.
My lord, I have submitted all the documents again, like, my lord, in page number 65 of my memo, the learned counsel has already given that it is respectively submitted that the plaintiff has not obtained a sanction plan from BBMP in respect of the property bearing number 9, and the construction of the building is illegal and unauthorized. This has been proved in 3 cases, my lord, and again, the same thing is coming up to the court, my lord.
Not dealing with the appeal. We have dealt with whatever we can deal with in the contempt jurisdiction. Yes, next.
Seal number 12, so PL matter, Mr. Nikhil Vittal Patil, 14%.
Well. What is 11? Achha. That
My lord,
The state government's response.
my lord, I apologize, my lord, the name of the government hasn't been reflected in this as appearing for respondents 2 to 4. It only shows the name of the Union of India. If my lord could grant me, my lord, a week's time, my lord, since the session is going on, my lord, I couldn't contact the concerned officers. If my lord could have it around 19, I could tentatively make a submission to my lord. Otherwise, my lord may have it on the reopening day. I leave it to my lord.
reopening.
Right.
My lords, I have some suggestions for the state governments, this committee. I have discussed this issue with architectural firm, Bombay based. They have conserved more than 300 heritage sites. It includes our Bombay High Court building. So they are also part of many such translocation projects. So they can consider Savani heritage. They are very positively send me this email.
What is this?
Actually, I got this yesterday, so I didn't get copy.
So please give me a copy.
What is this? Somebody has given certificate.
No, some private agency.
Private
I think he's saying government can make use of this agency.
Yes, they have conserved more than 300 such monuments.
You have to produce on record after they take instruction. Learned additional government advocate, Nilofer Akbar, wants time stating that his name is not reflected, and further that he would also need to take necessary instructions. Full stop. Request is accepted in the facts of the case. Tender over to January 17, January 6, January 20th.
Obligement.
Name of learned AGP shall be mentioned while notifying the petition on the next date. This you can give back.
Seal number 13.
Well, this is regarding the solid waste management public interest litigation. My lord is pleased to pass an order on 6/2/24, where the Honorable Court has directed Pollution Control Board along with BBMP, because my lord is pleased to recall, we had submitted that Pollution Control Board finds fault with the BBMP, saying that their facilities are not adequate. Therefore, my lord is pleased to direct that all the three stakeholders meet and have meetings. And we've had, my lord, 2 effective meetings.
Three
Three effective.
effective meetings.
No,
In one, my
One was
lord wasn't
adjourned.
present, yeah.
2 were effective meetings, and they have made certain commitments. If, my lord, they place a status report before the Honorable Court as to what action they have taken based on the 2 meetings, my lord. One was on 23/5/24 and one was on 10/7/24.
Who appear?
I apply for BBMP, my lords.
Status report is filed.
Yeah, my lords, that status report has been shared to me. It's already shared with the petitioners. I may be granted a day's time to have this filed tomorrow, my lords.
We
The
haven't
status
served a
report is
copy.
ready. I have to look into it. It may be, if this matter is taken up tomorrow, I'll have this filed in the registry, my lords.
Does it survive now?
My lords?
Yes, my lord. My lord, what happened is the petition was filed in 2012. One order of the court was dated 27/8/2012 for mandatory segregation of waste in the 3 mainstreams. Thereafter, there were 29/2012 was a comprehensive order on how waste should be segregated and processed and managed. Subsequently, my lord, this honorable court has agreed to.
You are segregating the waste.
Yes, my lords, there is effort.
No, they are not segregating, they are dumping.
No,
They are dumping in the quarry.
So Prashant,
Uh.
10/7 do ಕೊಡ್ತಾ ಇದ್ದೀರಾ? Proceedings 10/7. Proceedings. ನೋಡಿ. ನೋಡಿ ಇದು. ಸರಿ ಬಿಡಿ. ಇದೆಯಾ? ಹಾಕುದಾ?
you can, I do not have this.
Hmm?
I don't.
ಪ್ರಶಾಂತ್ ಇವ್ರಿಗೆ ಕೊಡಿ, ಅಜೇಶ್ಗೆ ಕೊಡಿ. ಅಜೇಶ್ಗೆ ಕೊಡಿ. Same. ಅಜೇಶ್ ಅಂತ.
Ajay. One sec. I may be granted 2 days time, my lord, so I shall file it.
Can I submit this, my lord, for my lord's?
My lord, could I file the proceedings of the meeting that was conducted on 10th of July 2023 with the stakeholders, my lord? Copy has been furnished.
My lord, what they'll have to point
Madam.
out, my lord, 19/4/21, this honorable court was pleased to pass an order to saying that more than 5,000 tons, my lord, that means more than 2/3 of the waste is lying unprocessed. Let them say, my lord, specifically to the honorable court, that is after 19/4/21, what capacity they have provided to process the waste, because it's an admission by them that only 1/3 of the waste is processed, 2/3 is put in the landfill.
No, these are the proceedings, but I am to inform to my lord that this had to be placed before my lord.
This is one of the minutes of the
Nobody
meeting which had occurred, my
participated.
lords. Yes, my lords.
I'm preparing for.
My lords, for BBP, yes, my lords.
Would like to file status report, which may be filed in course of the day, 10th or to 16th of.
My lord, one submission, my lord. Because this honorable court has taken on notice 19/4/21 that only 1/3 of the waste is processed. We have had meetings, my lord, and this is not an adversarial litigation. Even on the last date when the order was passed, we suggested that let the stakeholders, that is Pollution Control Board and BBMP, meet. What we have observed, my lord, in these two meetings, the direction was that my lords have been pleased to give various directions from 2012. And obviously, we don't want to waste the time of this honorable court. Now, when the two stakeholders are meeting, they should take each order of this honorable court, put a timeline, and say by when it will be implemented. Now, my lord, 2012 to 24, if they say to this honorable court, my capacity is not improved, and every year we have more than 1 million people and odd coming to Bangalore, then the problem will never go away. 2/3 is going to landfills. If we go to the outskirts, free gift they're giving the villagers is untreated garbage. Therefore, the leachate comes, it pollutes the groundwater and comes back as polluted vegetables to the city. Therefore, my lord, let them say to my lords, when they'll provide the capacity under the waste
We'll
management.
take up on 16th.
Our inspection report, I am for Pollution Control Board. Our inspection report states that they are dumping it in a waste quarries without separation,
Yes.
without segregation. That is the reason this honorable court is monitoring and supervising this case for the last 12 years. It is not improving.
We'll see on after you file the status report,
Yes, my
we'll
lord.
see what steps.
Copy may please be served.
Copy is shared.
Grateful.
16. So Prashant, right? 16.
Green bench matter, still number 14.
Yes,
No,
wait,
14.
please, my lords. Appearing for the petitioner's counsel, my lords. My lord, your lordship had directed the state to know what is the status of
My
the
lord,
application filed by others, my lords, because our claim is we belong to scheduled caste and we are traditional mining workers in respect of the scheduled property, which is produced at the end of the prayer in the writ petition, my lords. The petitioners, along with their family members, their ancestors have been working and eking their livelihood since centuries, my lords. And they are the only, this is the only source of income for them. Now the state wants to, my lord, to give this to third parties. Now, my lord, under Rule 3F, my lords, there is, my lord, we are entitled to preferential treatment, persons belonging to scheduled caste, one. Number two, for who are manual quarry workers. We are entitled to preferential treatment, my lords. 25% has to be allotted to them. Now, my lord, without considering this, my lord, they are proceeding. Now, my lord, there is in fact a direction by the director of the mining department also to consider application. Now, my lord, what has happened is the my quarry, other quarry owners, my lords, of other quarry who are owners of other quarries, they approach this honorable court, and this honorable court, as for Annexure K, issued directions, my lord, that their application be considered in accordance with the law under 31ZC, my lords. Now, my lord, the 31ZC application can be considered only if where the lands have been reserved, my lords, which is available for allotment. That once that is done, my lord, reservation has to be done. 25% has to go to this sector of people, my lords. Thereafterwards, out of them, some portion can be allotted for M sand under 31ZC. That exercise has never been done, my lords. Without doing that exercise straight away, they wish to grant to others.
My lord, on the last date of hearing, if my lords were to recollect, my lord, the petitioner's counsel made a submission that his application, my lord, which is at Annexure B, should be considered along with the applications of respondents number, my lord, 6 and 7. And my lord had directed me to find out the fate of these two applications. My lord, as far as respondent number 7 is concerned, my lord, their application has been considered. My lord, with regard to respondent number 6, it is still under process. Now, they had limited their prayer, my lord, only to consider the representation dated 9/1/2024. We will consider the representation in accordance with law.
May to take the honorable court to page 42, my lords. Page 42 with kind permission, my lords. The director, that's respond number 3, writes letter to the task force, my lords. Task force is 5, respond number 5, district task force. My lord, regard the claim of these petitioners, they write that has last para, my lords, page 43, last para. District Task Force Committee has to submit report about the action taken with respect to the grant of mining license to the traditional workers under Rule 3F on preferential basis as provided so and so. Now, my lord, in the light of this, kindly permit me to refer to 3F. 3F itself provides, my lords, preferential treatment to traditional quarry workers. Now, my lord, under 31B, my lord, blocks have to be identified and notified, and some portion has to be given to these traditional workers, and the remaining portion can be given, my lord, to Ms and other categories, my lords. This exercise has not been done. Without doing this exercise of reserving, first under 31B, reserving the blocks, my lords, identifying the blocks and reserving the blocks, they cannot proceed ahead because 31B.
I appear for respondent number 6.
My lord, the claim of the mining laborers, my lords, who do traditional mining is recognized under the act itself, my lords, under the rules. 31F provides for reservation to them, my lords, to the SC, STs, and also traditional workers. So they have to identify the block first without.
Milords, I'm instructed to appear for respondent number 6, who's one of the previous applicants under 31ZC. I'll file wakalat over the course of the day. My respectful submission, Milords, is that this issue is covered. And Milords, an application under 3F will not lie. Milords, unless a notification is issued. In the present case, Milords, my application under 31ZC, which starts with a non-obstante clause, is made in March 21. I am respondent number 6, who is one of the applicants under 31ZC.
Their claim is same.
I applied in March 2021. Please, Manoj. I first applied for this land.
No.
It is in its final stages because what happened was it was not considered under 31ZC. 31ZC is a special scheme which says that for Lords, would your Lordships kindly look at this judgment? Writ itself is not maintainable. It's a covered issue. Lords, kindly have your Lordships permit me one moment to place this judgment. Just give a copy to
Copy code.
My lord, the simple
Copy.
prayer was to consider the
Lords, 4th January 22, writ petition number 10369 of 21. Just kindly have a look at paras 5 to 7 minutes at page 4. Unless 3F conditions are satisfied, namely a notification is issued and my lords applications are called for, suo moto, my lords, at their instance an application cannot flow. Kindly have a look at para 5, my lords, at page 4. Your lordships have clearly held, my lords, that such a petition is not maintainable. If I may read, my lords, para 5. The submission is that no license can be granted on an application made by an applicant on its own and can be made only when the applications are invited and for which publication is to be made in 2 newspapers, then only such application can be considered. And then para 7, learned counsel for petitioners failed to show any provision under which an application preferred by petitioner society on its own can be considered for grant of lease, license or lease. Counsel tries to submit that some other societies have been granted lease for quarrying purpose on application moved by them. However, she has not been able to show any provision under which authorities can consider application preferred by society on its own. Now, my lords, in this case, it's an exact similar situation. I apply on 21st March 23. Because, my lords, it's not processed, my lords, I come to your lordship's court at page 50, your lordships issue a mandamus on 27th of May 24 to dispose of my application, my lords, within 2 months. That is by July 24. Now, my lords, my application is in its final stage. All the NOCs that I had to obtain under Rule 8 have been secured and placed before the granting authority. I've been waiting, my lords, for a year and 9 months. Now, my lords, at this stage, this society, which is constituted after 9 months after my application is filed, makes an application in January 24, when my application was already well under consideration. There is no notification under 3F. Now, the whole clock is set back.
MMC rules. Oh, my lord, the notice is not served. I appeared on instructions. My lord. Please, my lord.
Very well.
Lord,
Please,
Lord,
please. May I only,
Lord, I have
May I
only
get-
one
may I only
submission, my
one
lord. I'm
prayer, my
sorry, your
lords?
lordships have made the order, my lords. Lords, I have the benefit of an order that your lordships gave me, my lords, in May. I should not get tied up with this, my lords. My application should proceed.
My lords, your lords, may kindly. My lord, there is no notification, my lords. Without notification, they want to proceed ahead. May I only make one submission, my lords? Till my lords order, my lords, they complied with the, my lords, that they consider my representative, let them not give this land to anybody else. Before that, they want to give it. My lords, before
No,
that, they want to
that
give it now,
cannot be.
to respond number 6. Even before, they want to say that,
Lordships issued a
no,
Lord, your
respond number 6
lordships
is
issued a
present.
mandamus in my
Now they want
favor
to
to the
say,
authorities in May of 24.
they want to say, our application to be now considered,
That
nothing remains for
mandamus is
consideration.
already enforced. He doesn't challenge it. I already, my lords, have the benefit of a
Lord, we'll
mandamus.
There is no
consider the
notification.
office, my
It is all
lord.
done at the back end, my lords, without any notification. So till my lords.
I'm sorry, my lord, I didn't mean to. No, I apologize. No, my lord, I didn't mean to. Yeah, obliged, my lord.
Oh, bless. Lords, could it be 4 weeks, my lord, instead of 8 weeks?
My application to be considered, my
Could
lords.
it be 4 weeks instead?
My application to be
Very well.
considered after.
Very
Hearing is also there. Hearing, my lords, they want to, because traditional workers, my lords. Great.
Number 15. Mr. Shivati.
Right. Sorry.
Great.
Dictate again, simple man.
Number 15.
In the present petition, was challenging the notice issued by the respondent authority.
Yes.
Directing the petitioner payment of rupees 2,54,25,050 rupees, alleging that the petitioners are illegally extracted and transported mines of 72,643. My lord, issuance of notice is in violation of principles of natural justice without providing opportunity of hearing. My lord, a similar matter is listed on 3rd of January, 3rd December in WP number 30895/2024, in which, my lord, this honorable court directed the government to accept notice, and matter is posted on 7th January.
Not heard.
Coming up for the first time.
No, similar matter is listed on 3rd of December, my lord. Same is posted on January 7th.
They are not heard and penalty is imposed straight.
Could I just bring this to the notice of the authority and make my submission, my lord? The authority, let them not repeat this mistake. It is for this
We are
reason.
inclined to treat this notice
Notice.
or order as show cause notice.
Very well.
We'll pass that order. You hear them and complete the exercise within 6 weeks. Since admittedly you are not heard.
Yes, my lord,
Right?
not have.
We'll pass them. Yes, next.
AG.
Bill number.
Now serial number.
16. Okay. Your lordships were pleased to pass an order on 29th October.
What was 13?
13th was the previous matter.
13.
29th, 10.
No, 16.
This is on 29th October, your lordships had passed an order directing us to deposit 125 crores.
Oh, this is that.
We have deposited.
Within
we have-
24 hours, they deposited 125. Within 24 hours, they deposited 125 crores.
So powerful.
So I'm saying.
I thought state will be happy, but state seems to be unhappy.
I'm very happy, my lord. I wish they deposit one more 125 crores.
Wherever Mr. Phanindra is there, things are powerful.
Lord, the committee.
After vacation.
After vacation. The interim order may kindly be cut.
Whatever it
Please.
is, we'll go to which date? March? Nothing survives. We can dispose it. now.
No, my lord, because the committee has to give its report. Your lordships have,
All right.
it may come after vacation.
February
February.
Please,
28.
please,
28.
very.
Can I make one time, your lordship?
Time if granted earlier shall continue.
Time was granted for 4 weeks, my lords. Your lordship may extend it time till the next date
To
of
the
hearing.
committee.
To the committee to decide
first.
for 4 weeks, my lords. Your
The
lordship,
time is extended till the next date
please,
for the committee to take a decision as required in the earlier order.
please, grateful.
The writ appeal matters, seal number 17.
Lord, order copy. Second respondent. Lord, in this matter, lordships heard this matter for some time on 7th of November. Lord, the issue pertains to a direction given by the learned single judge, my lord, to grant 2 promotions without, my lord, considering the assessment of work that has been performed by the respondent. Grant of automatic promotion after reinstatement. Now, my lord, it was in fact directed today to be taken up for hearing on merits only. Lord, my problem is I should have filed a list of authorities. Now, my lord, lordship takes it up in the afternoon, I'll file it and then argue it.
Not after vacation. We'll take up. Immediately we'll take up in the January. It's 15th January.
Obliged.
18, 19 are urgent, seal number 20. Number 20,
120 is 122 deal, ladies. Is a fresh matter.
Yes,
Notice returnable.
Lord, the learned single judge, serious charges were, my lord, the respondent who was a very senior officer in the bank. Now, my lord, every account he permits overdraw and, my lord, exposing the bank to risk of, my lord, losing money. Now, my lord, every transaction, my lord, it is beyond the powers. Now, my lord, the learned single judge holds that the inquiry has been held properly. Learned single judge does not interfere with the findings of the inquiry officer. There are 13 charges. Now, my lord, only on the ground that, my lord, we have not alleged that he had misappropriated the amount. And, my lord, we have actually not shown what is the total extent of loss suffered by the bank. The learned single judge holds that the order of dismissal is excessive and grants compulsory retirement, converts it into. My lord, that is,
But there is a delay of 122.
yes.
So notice returnable on February 13.
Obliged.
Question number 21. Mr. Narendra Babu for appellants.
Appellant is the third respondent in the writ petition. Order was passed by the single judge, please, my lord, being agreed by that appellants are before this honorable court. First respondent herein has obtained financial assistance from the appellants, please, my lord. 84,19,942.
So why auction was held? After settlement in local, auction was held.
I'm representing the respondent number 2 and 3, my lord. The respondent number 1 is the borrower. He has
Respondent
arrived at a settlement with the appellant.
Grievance.
My lord. Now the only grievance is this, please, madam, the matter was settled in Lok Adalat. He was supposed to pay 84,19,942. He should have been totally cleared on 30th of April 22. He has not cleared that money. Subsequently, appellant herein has filed execution, that is CMIS, wherein arrest warrant was issued and thereafter attachment of movables, immovables were issued. Thereafter, the entire amount of rupees 84,19,942 is paid. He has taken 2 years more for clearing all those as he is committed in a Lok Adalat, please, my lord. Now, the question is that in the Lok Adalat, matter was settled and there was no clause of interest to be paid if it is delayed. Now, the single judge has considered to that effect, saying that in Lok Adalat, there is no clause to the effect that there is no interest to be paid. It is a financial assistance, financial company is a bank, please, the public money is there. If, just because Lok Adalat, there is no clause to the effect that there is no interest to be paid, then public money should be safeguarded and for 2 years delay. Now he has to pay around 14 lakhs and add 14 lakhs 47,054 rupees as the interest. In fact, before the single judge, please, my lord, on 14/3/24, earlier to that date, appellant herein was directed to come with a memo of calculation, what is the amount interest to be paid. We were there on 14/3/24 with memo of calculation, please, my lord. By the time change of bench was there in the court, and the change of bench, the single judge has passed an orders to the effect that
Pending interest is not liable to pay interest. A petition was by private party.
Not,
Borrower.
please.
He's
He's
the
the
borrower,
borrower,
my lord.
borrower, please.
Borrower.
He is borrower. Now the dispute is in relation to the interest, my lord. Paragraph 9 is the contention regarding the interest.
But why this, why, what makes you, it is in your, this is in, why, what makes you aggrieved?
My lord. Respondent number 1 here,
Interest.
only portion of interest, please, ma'am. Matter is settled in Lok Adalat, my lord.
Page 20, my lord, that is the finding.
Who will appear for it?
Respondent number 1 has to be notified. my lord.
Note.
This has to go.
What is the amount of interest?
14 lakhs 45, 7 lakhs,
Tax.
please, ma'am.
Dismissed.
Hello.
Lok Adalat settlement will.
Settlement.
Next.
My lord.
22,
We'll give the reasons. Dismissed. Appeal is dismissed.
My lord, may I submit, please, my lord? Before that. The matter is
Lok
actually,
Adalat settlement has to be given effect to.
my lord, that has been
Can't
given effect.
improve upon the Lok Adalat.
Well, if that is happening, what happens, people will not go for Lok Adalat. Lok Adalat settlement means if the Lok Adalat settlement is there, if they are going to settle the matter for after 10 years of Lok Adalat disposal.
In a given case, we'll see this can, yes.
number 22, the GS Prasanna Kumar appears for that.
Appellant. Your Lordship, the petitioner sought for the regularization. Your Lordship, appellant sought for the regularization and as per the annexure B, there is a clause and there 2001 notification, there is a specific class for the how to fill the unclear vacancies. Annexure B, page 34.
Where is that notification?
Your
Clause
Lordship,
6,
Annexure B, Your Lordship.
Annexure B.
Okay. It start from 33, 34. In unfilled
Sir,
vacancies,
close.
second class, Your Lordship.
We are on clause 6, huh? List of selected candidates.
That unfilled vacancies, D class in page 34. Class 2, the vacancies to the extent were not by belonging
Clause
to
6 does not give any preference.
class 2, Your Lordship, unfilled vacancies in that D.
Clause 6 does not give any preference. Does it give? Clause 6 of the notification dated 2001, which you relied on to seek the preference for appointment, does not give any preference.
No, your lordship, in that your lordship, kindly see that next page in definition class, unfilled vacancies, sir.
Where is that? At page, which page?
Page 34,
34. Oh,
unfilled vacancies, the second class, your lordship. That vacancies to the extent where not filled the person belonging to scheduled caste and scheduled type. So the case may be as per the classifications of the vacancies in accordance with the order of the reservation applicable to the direct recruitment while regularizing the service of the daily employee. The first class that only those persons were, because the petitioner is working from 2012, 2018, they call that. Almost 12 years I am that in. I sought for the regularization as per the 1990 August notification.
where is that preference?
Kindly see the 1990 notification also for regularization.
What you are showing?
2001, there's clear reference about that. Applicable to direct recruitment while regularizing the service of the daily wages employees as per the government order.
What you are producing?
DPR, because what the 2001 reference about that 1990 rules should be followed for the regularized before the going for the appointment. So now,
That's a different question. That is, for that you file a separate petition. Here you are seeking preference.
no, in this petition also I sought for the regularization also.
Then did you rely on this people on a single day?
Yes, your lordship. The learned single judge also observed that, but they are not given preferential for that regularization.
There is no preference.
Your lordship, in the first para itself. Petitioner claims entitled for the preferential treatment as.
But it was a regular appointment pursuant to advertisement. It was a regular appointment pursuant to recruitment process.
Yes, your lordship, para 7 of the single judge. Yes,
The process in which you appeared was a regular process pursuant to issuance of advertisement.
yes, your lordship. In para 7 of the learned single judge order also, he observed that. But in one sentence, in the light for.
Where is that endorsement page? Annexure J.
Yes. University in 2024 also, based on the representation, regularize the similar D group employees. Along with my memo, I produced that also, that is in Kannada.
Sorry, heard learned advocate Mr. So-and-so for the appellant. The present appeal at the instance of original petitioner is directed against judgment and order dated 1st April 24, passed by learned single judge dismissing the writ petition of the appellant petitioner. What was prayed paragraph in the writ petition was to set aside the endorsement dated 11/3/2020 issued by the respondent. It was further prayed to direct the respondent to consider the petitioner's representation dated 20th/08/2020 and to appoint him on the post of the peon. First of the facts in the background, the petitioner, the facts in the background were that the respondent, Bangalore University, invited applications for the post of peon into bracket schedule type, tribe, general under the backlog by notifications dated 23/10/18 and 24/11/18. 124 applications were received, which included the application of the petitioner. Full stop. The applications were scrutinized and the provisional merit list was prepared on 11/9/19, which was published on the website of the university. It appears that the name of the, the name of the petitioner figured at serial number 49 in the final seniority list which was published. It appears that the petitioner appellant had certain objections which were raised on 13/9/19 and 24/9/19. The university reviewed the same and final merit list was published in which the petitioner, who was at serial number 49, could not find the place. Was not selected for appointment. It was recorded in the impugned endorsement that there were sufficient number of candidates who had attained age of 29 years, but were within age of 40 years. निकाल last. The entire case of the petitioner was that since he was already in service under the university on contractual basis as D group employee, whom he should have been given preference while making appointment pursuant to the aforesaid recruitment exercise. He relied on, in support of his case, clause 6 of the notification dated 21st November 2001. The said clause 6, on the basis of which the preference was claimed for appointment by the petitioner appellant, reads as under. Then it is at page 35. 6, list of selected candidates. Known as single judge observed to take a view that the aforementioned notification does not provide for any preference. The case of the petitioner that since he was in contractual employment, should be given a priority consideration in terms of the said notification for the purpose of appointment was negative. Learner single judge noted that even if the benefit is extended to the petitioner, the last selected candidates had secured 79.20%, whereas the petitioner had secured 39.36%. Therefore, even with 4.4% weightage, the petitioner would remain ineligible. It was further observed by learned single judge that the plea of the petitioner, the prayer of the petitioner for regularization was not liable to be entertained, inasmuch as the petitioner had participated in the recruitment process and secured only 39.36% against a selected candidate who was selected purely on merit, having secured 79.20%. Full stop. Even when the academic merit and the achievement of the successful candidate are juxtaposed with that of the petitioner's apostrophes. Even after giving the service weightage of 4% from as recorded above, the petitioner would not attain the competitive merit to remain ineligible. Full stop. Aforesaid are the weighty reasons which have rightly been weighed with learned single judge in not granting the relief to the petitioner and dismissing the petition. Full stop. The petitioner participated in the open recruitment process and could not pair a FARE on merits. Full stop. His case for preference on the ground of clause 6 is entirely misconceived and not tenable. Full stop. Merely because the petitioner was in contractual employment of the university, he could not have been even otherwise given preference. Full stop. He has to compete openly with other candidates, which he did and failed on merits. No error could be pointed out in the impugned judgment and order of learned single judge. The present writ appeal is dismissed.
Your Lordship, one review, Your Lordship, this order may not come in the way of the petitioner may seek for that, appellant may seek sought for the regularization on the basis of that is continuation of service.
This judgment will not come in way of the claim of the petitioner, if available in law and in accordance with the rule, for absorption in service on the basis of length of its service. Correct?
Regularization.
This court does not express any opinion, as there is no occasion to go on the said aspect.
23 urgent, number 24, Mr. Keshamurthy.
23 urgent.
Your Lordship, the order of the learned single judge goes on with respect to demolition of certain violated structures.
Delay 197 days. Returnable on 3rd February.
Might I only request no precipitative action, Your Lordship, direction to the
There is
BBMP.
a delay, no interim order.
I understand. Obliged.
It can be early, little earlier.
Please.
17th January.
Obliged.
Number 25, Mr. Shrikant MP.
For appellate. Lord, the private respondent preferred my lord's revision petition, contending that my lord's he is the principal and my lord's someone else is posted in his place as the principal. Lord, the facts are that my lord's
It was upon inquiry,
please, my lord.
upon disciplinary inquiry.
No, my lords. My lords, what happened, my lords, was that the private respondent, he never took charge, my lords, of the post of principal. In fact, he worked under someone else, my lords, throughout. My lords, after, my lords, the another person was, my lords, posted as the principal. My lords, he challenged the appointment. My lords, the revision petition, my lords, was disposed of, my lords, at least on 3 occasions earlier. And my lords, when the matter was remanded back, my lord, the authority said that indeed his, my lords, the nature of prayer which is sought is his reduction in rank, for which he has to go to, my lords, the Education Appellate Tribunal under Section 94 of the Karnataka Education Act. By preferring an appeal, he cannot maintain a revision petition before the authority concerned. My lord, that was challenged, my lords, before the learned single judge. My lord, during the pendency, my lords, another person, my lords, was appointed as, my lord, the then incumbent principal was relieved. And my lords, without challenging, my lord, the appointment of the present principal, and admittedly, there was no interim order, my lords, throughout in his favor. My lords, from 2009, my lords, till the date of the order, the learned single judge, my lords, awards back wages also. Admittedly, my lords, he was before the authorities challenging the orders.
What was this order 18/4/13?
Please, my lord.
Which is, where is that order? 18/4/13, which is set aside by learned single.
My lords, may have a look at.
At which page it is?
My lord, what was challenged was the order which I have produced before your lordship, my lord, which is the order, my lords, whereby the private respondent, my lords, was appointed as the principal. That I produced, my lords, along with my objections, my lords, to the writ petition. The order, my lords, 15/7/2009 is at page number 178. my
No,
lords.
no,
Please.
18/4/13.
That is at page 87, my lord, annexure F, the order in revision.
57 is next ref,
Please,
same order,
please, my lord, page number 97 is the operative portion,
90.
18/4/2013.
Starts with 93 minutes.
There must be a mismatch in the copy which I have, my lord, annexure.
Heard learned advocate, Mr. So and so, the appellant. Notice returnable on first March, the impugned judgment and order shall remain state.
Lord's, fifth respondent is, Lord's, represented by K. Vetam, Lord's, copies are served.
Learned advocate, Mr. So and so, Harish.
I'll take notice for R1 minute.
Learned additional government advocate, Harish.
1 and 2, my lords.
Today, who is the principal, but
Please, my lord.
today any principal is functioning?
My lords, there is another principal, my lords, who was appointed during the pendency of the petition, not the private respondent. In fact, retires by this month end, my lords, for
Heard,
15 days.
Heard learned so and so, as well as learned advocate, Mr. Harish, additional government who appears for the month. It was submitted with reference to the impugned order that during the pendency of the petition,
Please,
there is already an appointment of another principal.
Please.
Who has been functioning and holding the charge.
Please.
Regular principal.
Please.
Full stop. In the facts of the case and having regard to the directions received by learned single judge, notice returnable on first March, the impugned judgment and order and the directions issued by learned single judge in the operative part shall remain state.
Please.
Full stop. Learned advocate for respondent number 1. Learned advocate, Mr. Harish. Harish.
Please.
Learned, it is government advocate. Accepts notice on behalf of.
Respondent number 1.
The rest shall be served.
So, commercial appeals, seal number 26. Mr. Prakash.
For the respondent, for the appellant, my lord. The appellant pursuing the order dated, my lord, 21st August 2023, my lord. Respondent filed the application under section of the Arbitration and Conciliation Act, my lord. The appellant is a tenant under the respondent, my lord. The lease agreement dated, my lord, on 18/10/2019, my lord. The comments on 1/1/2020 to 1/1/2029.
Notice returnable on.
My lord, last occasion, my lord, directed me to produce the check which is bounced, issued by the appellant, my lord. By way of additional documents, I have produced it, my lord. Since day one, I have not been given rents, my lord.
On the reopening, we'll consider. 5th February.
Number 27. Chandini. 27.
May it please, your lordships, for the appellant in this matter, your lordships. On the last occasion, your lordships had asked for deposit amount to be submitted. Your lordships, we are financially incapacitated to pay. Any meager amount may be given. We need to press for stay, your lordships.
Where is the order?
The order is
Requiring you to
actually page number.
There is
Order amount in the order, your lordships. Amount in the order you're asking.
Have we passed you any order to deposit?
No.
directly?
But on the last occasion, the matter was adjourned stating that I had to deposit certain amounts. However, I have paid the requisite court fee. And also,
That is not the question. Money-
yes, your lordship.
So today, what is the position?
Your lordships, we are ready to pay some. We are ready to pay some amount, your lordships, in persons to
Let
deposit.
it go beyond. the question.
Your lordships, maybe the 20% may be ordered to deposit
Take
for
a-
INM.
After vacation, whatever, there is no stay nor any,
Yes, I want a stay, your lordships. I'm
then
pressing
deposit
for
the
a
entire
stay.
amount.
Your lordships?
Then deposit the entire amount.
Your lordships, 20% is possible, your lordships. Kindly, your lordships. Your lordships, we were not liable to pay in the first place to begin with, your lordships.
do you
And
want?
the liability falls on the defendant number 3.
Shall we pass the order requiring to deposit and staying the judgment and decree, or shall adjourn simply?
Your lordships, 20%, your lordships, please. Please, your lordships. I'm
There is no
humbly
question of
requesting.
bargaining. It's a money decree you have to pay.
Yes, your lordships, but it is also on the discretion of the court to reduce the amount when I am not liable
There is
to.
discretion up to
pay.
20%, 80% to deposit.
Your lordships, there's a clear non-application of
Now
judicious
decide
mind.
what do you want. If you want stay, we'll grant stay on condition of deposit of 80%. Otherwise, simply adjourn the matter.
Your lordships, I'll consult with my senior
Not-
ones.
no
your lordships.
time.
I'll have a word with my senior because I was only authorized to go up to 20%. But now that you're
Not
telling.
be authorized to anything, mister.
Yes,
Don't
sir.
make such statement before the court of law. We are not bound your instructions, not bound your statement.
No, I'm ready. I agree, your lordships.
Next.
Vacation. Number 28. State appeal.
Here for the respondents in this case.
Eight appeal, my lords,
Please.
37, my lords. A divergent finding by my lords, the learned arbitrator rejects it, my lords, and in 34, my lords, in the modified order for partly considering, my lords, which is not permissible, my lords. There is a delay of 111 days, my lords, in application.
Delay is that
Yes, my lords.
Well, it's,
notice returnable.
well, it's subject to what my learned senior wants to say, like,
Your appeal.
may make a suggestion, my lord. Let the matter be remanded back to section 34, my lord. Let it be
And all
adjudicated
parties are
afresh.
appearing.
Please,
All parties are appearing.
yes,
You are appearing.
pardon, my lord. I am for the respondent.
For all the respondents.
Yes, only one
Only
respondent.
respondent, only respondent.
Only one respondent was the contractor, my lord.
All three, my lords.
All three, please.
Heard, so will delay is to be condoned, heard learned advocate, senior advocate, so and so assisted by learned advocate, so and so, and learned advocate, so and so the respondent. This application is filed seeking to condone the delay of 108 days. It's taken place in preparing the present commercial appeal. Full stop. The reasons stated in the accompanying affidavit paragraph spells out the reasons for the ground stated in the accompanying affidavit spells out the reasons leading to passage of time and resultant delay. Full stop. It could not be said that the delay has occurred due to any indolence or negligence on part of the appellant, more particularly when the appellant is a public works and water transfer department, an impersonal body, where the decision-making process invariably consumes some time. In the effects of the case, therefore, paragraph, sufficient cause is made out to condone the delay of 111 days. Delay is condoned, application is allowed. Now, come on, what is the appeal?
Please, my lord.
Appeal, what do you say about the impugned judgment and decree?
Well, there is a modification in the section 34 or what, my lords. There's a,
So how can the court modify court has become arbitrator in awarding the,
at the
Yes,
same
my
time, my
lords.
lords, the
Not
pleadings
a-
of the appellants have not been considered. At the same
no,
time.
3 lakhs the damages is awarded.
Damages has been awarded, my lords, and the 1 lakh rupee, my lords, is reserved amount returned with a 10% interest from date of deposit, my lords. It can't be, my lord, because deposit would be refunded only on completion of work. From date of completion of work, my lord, it would have.
And what is the amount awarded by the arbitrator?
No, my lord, plaint has been rejected. The claim has been rejected completely on the ground of limitation, my lords.
Claim is rejected.
Rejected, my lords.
And this
That's-
amount is awarded.
Yes, my lord. In 34.
Order in appeal, heard learned advocate, Mr. Senior advocate, so and so, assisted by learned advocate, so and so, from a while, at length, for the purpose of admission of the appeal, as well as grant of stay or otherwise. Full stop. The judge, it is the judgment and order dated 30th March 2024, passed by 80 Fourth additional civil session judge, Commercial Court, Bengaluru, in commercial application number, commercial arbitration petition number 197/23, which is under challenge in this appeal. Full stop. Learned the court below. Yes, such upheld the arbitral award.
No, my lords, altered, modified.
What is the award, arbitral award?
Arbitral award is, the claim is rejected.
Upheld the award of the arbitrator rejecting the claim. However, at the same time, in its operative order, directed as under, quote this one. Applicant is entitled to realization. वहां से लेके 3 paragraphs. Quote करो, page 42-44. This is the green. While confirming the arbitral award which rejected the claim of the claimant on the ground of limitation, comma, the court exercising powers under section 37 of the act directed the applicant to refund the reserve amount of 1 lakh with 10% and further directed
Consolidated damage of 3 lakhs.
appellant to pay the amount of damage of 3 lakhs, full stop. The court has prima facie acted beyond its jurisdiction in passing such direction. Appeal is admitted, the impugned judgment and decree shall remain state during the pendency of the appeal. This can't be done. Modifying the order, very apparent.
The copies have not been served. May I request.
Copy need not be served. Who served the copy?
Will serve.
May I request for the,
So apparent that we could have heard.
may I request for the court to fix a date, my lords, for, we'll file our objections.
Bill may be listed for final hearing in the week beginning from 22nd April.
Highly obliged. Next, two similar
29,
matters, my lords,
30.
between same parties, my lords. Same order, my lords.
Same order.
Similar order.
Is listed today.
Today, my lords, 29 and 30.
29.
Between same parties.
29 and
same.
30, na? So
I-
same
same
order. Date is same.
Same, state is
But
also.
suit, etc. will be.
But may I request for
Highly
any
obliged.
date in January, my lord. May I request for any date in January. I'm being aggrieved by the arbitral award. I've been aggrieved by the arbitral award. I've made to wait in the project site for more than a year, my lord, because of the delay which was attributable to the respondents. My lords, I have a good case on merits, my lord, since it may be,
That day will come in the week of 22nd of April.
may I request for January, my lord. In January or February, my lord, please. my lord.
Everything is houseful.
So ready notice matters. Number 31 to Vishwanath. Yes, the writ petition PA.
PIL.
Yes, ma'am. My lord, mine is a simple case for strict implementation of the ward committees, my lord. In the last date of hearing,
Board committee.
my lord, sufficient time is given, my lord, sufficient, more than sufficient time.
5th March.
My lord, more than sufficient time is given, at least in January.
Like 5th February, 1 month delayed. 5th February. Next.
So number 32.
For the petitioner, my lord.
Yes, Kalyan.
Take a short adjournment. Senior is unavailable. We had in January or February. Senior is unavailable today. Lords. He's traveling.
You are also senior.
Date change.
You are not senior. Is PIL?
PAL, my lord. This is regarding using of the civic community sites in HL third stage. The petitioner is also it's a citizen forum of the HL third stage, my lords. The area earmarked for a temple is been used to construction is coming up there. So
6th February.
oblige, my lords.
So number 33. B. Vidulata.
The petitioner, my lordship, kindly pass over the matter. Senior is held up in.
Not password, it will go to January. 21st January.
Bill number 34,
Ma'am.
the Shiv Prasad Shantangowda.
Petitioner. I'm challenging the endorsement issued wherein my application for mining lease has been rejected. I made an application on 25/3/2014 for a mining lease. To mine a building stone. Thereafter, my lords, my application came to be rejected on the ground that 2016.
Is filed. Reply may be filed for next week, next day, stand over to 13th February.
Bill number 35,
Madam, I am for the appellant, my lord.
Cash.
Appellant died on, my lord, 19/11/2024, my lord. Therefore, I have filed a lesser application. The appellant, my lord, died on 19/11/2024. I filed a lesser application. LR application.
So time.
Yes, ma'am.
Appellant is reported to be dead there. Application is
Response
filed.
time.
Filed.
The request of learned advocate for the petition.
Interim order may be extended.
19th February.
Interim order may be extended. Interim order may be
Interim
extended.
order shall operate if it is there.
Yes.
Bill number 36, Mr. Pradeep Saukar. 36.
Respondent, my lord.
The appellant, please, my lords. Lords, the appellant is Vijaya Bank, which is now. The respondent was selected provisionally as a probationary manager general on 16/9/2011, my lords. Then he accepted the terms of appointment with a annexure R3, my lords. One of the terms of appointment was that two terms were cast on him, that he will complete his CA examinations and that he will serve the bank for 3 years and he would offer
What is that bond condition?
my lords?
Condition of the bond, where is that?
Condition of the bond, my lords, is at, so the page 58, my lords. This is the annexure A, the selection letter at page 58, the last clause, my lords, K. You are required to serve the bank for a minimum period of 3 years from the date of joining the bank and should execute an indemnity bond for rupees 3 lakhs. The said amount has to be paid by you in case you resign from the service of the bank before completion of the stipulated minimum period 3 years. For this purpose, you have to bring a blank non-judicial stamp paper of requisite value procured in the state of your joining, Karnataka.
So the reasoning of the learned single judge that he served in the public sector undertaking, there is no backing.
My lord, they have
You
provided.
are supposed to serve in that very bank.
Plus, I have also filed a memo subsequently in this matter on 6th of August 2024. And there is a clarification that is issued on the website itself, which says that the DPE guideline will not apply to banks.
This page 58 is DB guideline.
No. The page 58 is the bank's own
Banks
internal,
own.
yes.
Which are the other guidelines?
There is a, what is they rely upon, please?
Department of Finance.
Yes, we are under the Department of Finance or the Ministry of Finance.
Which are the other guidelines?
There is no, in so what they are relying upon, please, my lords, is annexure R5, please, my lords. That is at, type of copy is at page 128. This is what is issued by the DPE, which
What is
said
the Department of
public enterprise,
Public Enterprise?
public enterprise.
So that
Here,
your memo says that it will not apply.
yes, please.
How?
No, this is because the ministries and the departments are different plots. This is issued by the DPE to say that if you kindly see page 129, please, my lords. Clause B. The terms of bond whereby an employee of a central public enterprise receiving
You are
scientific and,
Central Public Enterprise.
my lords,
Yes.
Though I'm a public sector bank,
Bank.
my administrative control is not with the Department of Public Enterprise. It is with the Department of Finance. And I have clarified that in my letter, please, my lords. Kindly see the letter at annexure E, page 84. And he has paid that amount at the time of resignation within 2 months of his appointment.
Can you share, can you show us from somewhere that your administrative control lies with the finance department?
I have stated so in annexure E, my lords, as a bank. Please kindly see annexure E, page 84. Public sector banks, nationalized banks are guided by the
Page-
page 84. This is a typed copy. The document is on the previous page. Public sector banks, nationalized banks are guided by directions, instructions issued by a parent ministry, that is the Department of Financial Services or the Department of Economic Affairs, Banking Division, Ministry of Finance, Government of India. We have not received any guidelines regarding transfer of
Yes,
indemnity.
what you have to say.
Yes, my lord. My lord, may be pleased to take annexure R5. I'll come to the point, my lord. Annexure R5 in their booklet at 127 page number. The entire orders passed in the writ petition is based on this annexure, my lord. Now, I'll take at the concluding part, point 2. First, I'll read that, my lord, it permits. All the administrative ministries or departments are requested to kindly issue necessary instructions according to the public sector enterprise under the administrative control. In addition, my lord, I would like to read point A, B, and C. My lord, a relevant point is the bond executed by an employee of public enterprise who have received a scientific or technical training at the cost of public enterprises and have applied through proper channel during the currency of bond, joint central government or a state government services, or take up the employment under quasi-government organization or any other public enterprise, either on a basis of competition, examination, test, interview organized by those organizations or Union Public Service Commission, should not be enforced subject to the condition that the fresh bond is taken to ensure that the employee serves the new employer for the balance organization bond period. The condition is of the transfer of indemnity bond is that the person should, if he is employed in another public sector enterprise, not a private sector, public sector enterprise, and he should fulfill that indemnity bond period, he should complete the tenure of employment mentioned in indemnity bond period in other public sector enterprise. Second point is the term of bond whereby an employee of central public enterprise receiving a scientific technical training out of expense of government or public sector enterprise undertakes to repay this specified amount in event of his failure to serve the enterprise for the stipulated period after the completion of his training should not be enforced against the employee who leaves the service of public enterprise to secure with the proper permission employment under the central government, public enterprise, or an autonomous body wholly or substantially owned, financed, controlled by the central or state government. If any public sector enterprise is controlled or financed by any of the government or state government, central or state government, then in that case also, he does not have to furnish the indemnity bond amount. Third point is C, to ensure that the requirement of obtaining fresh bond from the person where necessary is fulfilled, the enterprise with whom the employee has executed the original bond may at the time of forwarding this application write to the organization
Now, at that point of time, he has already written a letter. They are saying, I have paid the amount without protest and demo. He had already mentioned about this public sector enterprise guidelines applicability in his letter before making the payment of the fee. They have forced him to make, and they are saying they don't know about the guidelines.
Or learned advocate, Mr.
My
Quran.
lord, if my lords, may I please take my lords to the memo that I had filed, my lords? This is the frequently asked questions that I have downloaded and produced from the website of the Department of Public Enterprise, my lords. The memo is of 6/8/2024, my lords. If my lords see the second page and question number 2, is DPE guidelines applicable uniformly to all CPSCs is the question. The guidelines issued by the GM division of DPE are common to all central public sector enterprises, subject to the condition laid down in a guideline. If any CPSCs evolve rules and regulations in respect of their day-to-day work, under which broad guidelines issued by the government from time to time. However, these CPSCs which are in banking, insurance, and financial sectors, DPE's guidelines are not applicable to those. And CPSCs functioning in banking, insurance, and financial sectors come under the jurisdiction of the Department of Financial Services, Ministry of Finance, GOI.
Or learned advocate.
My lord,
Great.
one sir.
Pradeep Savarkar.
S.R. Kamalacharan, my lords.
Pardon?
S.R. Kamalacharan.
S.R. Kamalacharan for the appellant and learned advocate, Miss.
Harmal Shirin Shabir Bhai, I'll write my lord,
So-
one
so-
submission in that regards of the memo.
For the response.
I would like to
For my
take
outline.
question number 12 in that memo. What is the procedure of transfer of bond given by an employee of one CPSC to another CPSC in the case of selection of employee in another CPSC? This is a general question, my lord. They have not placed the DPE guidelines, but to that reply has came in regards to the DPE guidelines, which we are currently referring at. OM so and so, dated 29/7/2004, the enforcement or transfer of bond in respect to the employee of the central public sector enterprise who leave the services of one CPSC to join another CPSC or government organization may be seen in the content, which itself is self-explanatory. Again, my lord, I would like to take my lord to the question number 21, which shows that the circumstances under which any CPSC can deviate from the DPE guidelines. Why I'm taking this point, my lord, they are explicitly saying that these guidelines are not applicable. If any modification of anything is there, they can do with the permission of an administrative ministry or department of CPSC. And such modification instructions are not placed before this honorable court. Hence, the said DPE guidelines, though they are not aware, was brought into their recognition, awareness by the respondent, by the letter dated, there's a letter given to him, and to which the reply has been already read before this honorable court, my lord. So based on this too, in their memo also, they clarify that DPE guidelines are applicable, and as per that, they are not justified to take the indemnity bond amount. That's
At length, learned of the respective parties stated that they argued the appeal. Finally, they further stated that the pleadings are complete and no further are required to be added or supplemented, reserved for judgment. Grateful, please.
obligement.
Delay is there, delay gone down. Delay malice. I1 of 74, heard learned.
122 days delay, my
The
lords.
delay of 224 has taken place in preparing the appeal. The accompanying affidavit filed by the bank explains the passage of time, full stop. Since the bank is an impersonal body, decision making therein before it culminates to decide to prefer appeal, necessarily consumes some time. These administrative reasons would be said to be constituting a sufficient cause. Therefore, paragraph delay of 224 is explained. Sufficient cause is made out. Application is allowed.
My lords may permit me.
What is that?
The judgments on court, they are saying we coerced. They are saying that we have coerced him to pay the money, etc. On those issues, there are some judgments. And there is also a judgment of, I think, Kerala High Court where they have accepted that bond has to be
Give
paid.
copy to them.
I've given copies, but I'm grateful.
This number 37.
My lords, I appear for the appellant in this matter.
I'm representing third respondent in this case, my lord.
My lords, the issue involved in this case is covered by many judgments of this honorable court. My lords, whether a suit filed against a dead person, is it maintainable or not? Here the appeal is filed by the respondent, second respondent against a petitioner's father who died in the year 1991, in spite of having knowledge about it. My lords, may I tell in brief about the facts of this case, my lords? Certain lands were regranted under the Karnataka Village Officers Abolition Act in favor of petitioner's father in the year 1977. And accordingly, mutation is also transferred into his name by MR 32 of 1977-78. Since then, his name is being entered in the revenue records in the RTC of this concerned land. My lords, about 4 decades back, this one Srinivas Murthy, he shifted to Chennai and he settled there with his family. His children, the present petitioners, they moved an application for transfer of the name in the revenue entries, my lords, in the year 1922. Tahsildar wide order dated 11th May 2022 has passed accepting the order passed under Village Office Inam Abolition Act, and he has directed for change of the name in the name of petitioner's father. That order, the second respondent has challenged, deliberately mentioning and giving the address, in which address they have left about 4 decades back. When we have come to know about this through paper publication, we moved a memo. My lords may kindly see the memo informing the court along with supporting judgments. It is at page 37, Annexure E. We have informed the authority that the respondent passed away in the year 1991. And the appeal against the dead person is not maintainable. My lords, we have produced the judgments also. But ignoring all this, my lords, he says, no, you can come on record by filing an application for coming on record as errors. That is not the position in law, my lords. Against the sole defendant who is dead, any case filed is a nullity. My lords, may kindly see some of the judgments which we have produced, my lords.
You are challenging page 13 order? You are challenging order at page 13?
Yes, my lords.
So what is wrong with this order? So number 1 has died in the proceedings, then the legal error is permitted to be pleaded.
No, that is not the person. Kindly see the judgments, my lords. That is, while the case is pending, if someone is dead, that person is right. When a person is dead, he has his legal has to come on record. But here is a case where the case itself is filed against a person who is dead about 30 years back. This court has held, even if the person who has filed the case is ignorant of the fact that the respondent is dead, the court said nothing doing, it's a nullity. My lords, may kindly see the judgment. My lords, may kindly see the provisions under Order 22, Rule 4, which says, in case where the proceedings are pending, while the proceedings are pending, if a person is dead, no doubt the position held by the single bench and the order passed by the revenue authority is correct. While the matter is pending, if someone dies, we have to bring their errors on record. But here the case itself is filed against a dead person. That is against all the principles and canons of CPC.
I'm representing the third respondent, who is the contesting respondent before your lordship. Your lordship may kindly look into Annexure C for a moment. This is a revenue
There are
record.
only 2 respondents in this.
No, may I complete this. This is a revenue record. The typed copies is also made available to your lordship. The name of H. Srinivas Murthy, Annexure C, my lord. The name of H. Srinivas Murthy is shown as a khathedar of this survey number 60 by virtue of a mutation order dated 26/2022, my lord.
As on June 22, the name of H. Srinivas Murthy is shown as a Khatadar, my lord. A revenue appeal came to be filed by the third respondent in the month of October 2022. Hardly there 4 months. In 4 months, how the respondent number 3 came to know that H. Srinivas Murthy is not alive. When he was not alive, when he died in the year 1990, how his name could be entered in the RTC in the year 2022. Therefore, an appeal was filed, and later we came to know that H. Srinivas Murthy died because the LRs came into picture and they filed a memo. Immediately, these LRs were impleted and appeal memo was also amended, my lord. Appeal memo was also amended. And the revenue appeal also.
My lord, may I bring on filing this appeal? This respondent has filed an application and obtained all the certified copies from the revenue authority, which clearly shows that he is aware.
So they amend it and it has been allowed.
My lord, the said revenue appeal is already been disposed of, my lord, in the month of May 2024.
That matter should be contempt of court. We have brought this to the notice of the revenue authority.
So he was already impleted, Mr.
Yes, my lord, already impleted, my lord.
Oh. Where is that page? How do you demonstrate that?
The impleted amended appeal memo has not been filed by the appellants.
My lord, he could not implead as in this matter is our contention.
But then you raised their contention that he already impleted.
It is already raised, my lord. My lord, may kindly see the memo which is placed on record here at page 37. Annexer E. My lord, in the judgments which we have produced along with it clearly says there is no question of believing in the bona fides of the petitioner or the plaintiff. That won't change the position of law.
So they are already brought on record, Mr. Counsel. At page 56, it is reflected by order dated 31/8/23.
My lords, may for a moment kindly see page 38, my lords. Page 38. This revision petition which is directed against the order of
Learned
this.
advocate, Mr. So and so, for the appellant, and learned advocate so and so, so and so and so, who both appeared through video conferencing to make their submissions. Learn a single judge by judgment and order. Learn a single judge by the order dated 8th November 23, dismiss the petition of the appellant. what was sprayed by the appellant petitioner in his writ petition was to issue prohibition against respondent 1 authority. That's Assistant Commissioner, Dodda Ballapura Taluka, Dodda Ballapura, Bangalore Rural, not to conclude the proceedings on the ground that respondent 1 had passed away. Respondent 1 was one H. Srinivasa Murthy, who died during the pendency of the.
Not during the pendency,
Not
my
during
lords,
the-
in 1991 he died.
in
We have
19
produced the death certificate also. Kindly see the
On-
memo
on-
which we placed before
yes.
the revenue authority. That is not our contest. Our contest is against a dead person is a nullity and hence the appeal is not maintainable.
On 13/9/1991. Learned single judge observed thus while dismissing the writ petition and not granting the prayer, extracting from paragraph 3, the bracketed portion paragraph 3. The record of the appeal bears out into bracket annexure F, page 56, bracket over, that the legal heirs and representatives of respondent 1, H. Srinivasa Murthy, were already brought on record.
That's not the order sheet what it reads, my lords. We are not brought on record.
Before respondent 1 on 31/8/23. This is reflected from the order sheet of the proceedings. Into bracket page 56, Mr. F, again repeat it. Mentioning thus against the date 31/8/23. Inverted comma. Continuity. The colon, then inverted comma. Case heard, full stop. Advocate R1 present, comma, petitioner present, full stop.
R3, madam.
LRS of R1, moved memo, amend plaint, next hearing 12/10. Thus, the plaint is permitted to be amended by permitting the LRS to be on record. Full stop.
That is the illegality which we are questioning in this case, which was questioned before learned single bench also. My lords is reading the order at page 56. My lords may kindly see the memo which we have placed on record. The learned revenue authority doesn't state what is stated in our memo. He just dictates some order at his whims. Kindly see the memo at page 37. Which is referred at page 56, which my lords has just now read. We have filed a memo. Kindly see what is the memo that we have produced before the authority.
It is in above light that the learner single judge appears to have dismissed the prayer in the petition. Learned advocate for the appellant would submit that the memo moved by them indicated otherwise. Full stop. Be as it may. Full stop. While not entertaining the appeal, comma, this court observes that all the contentions of both the parties, including the contention about the bringing on record the legal heirs and representatives of the deceased number 1, as well as the maintainability of the proceedings, are kept open to be agitated before the disciplinary authority in accordance with law. With such observations, the appeal is not entertained.
Thirty-eight. Ashok P.
Your Lordship, for the appellant, Your Lordship, the appellant is an assistant executive engineer, Your Lordship. He was transferred by order dated 31/10/2023, Your Lordship, in page number 90, Your Lordship, a translated copy. In page number 94, Your Lordship, at serial number 54 and 55, Your Lordship. The respondent number 3 challenged the said transfer order before the Honorable Single Judge, Your Lordship. They said writ petition was allowed, Your Lordship, setting aside the transfer order insofar as the respondent number 3 is concerned, Your Lordship. On the ground that, Your Lordship, that is a premature and the reasons are not recorded for transferring the respondent number 3, Your Lordship. Your Lordship, I have placed editions of this honorable court rendered in writ petition number 24786 of 2023 is KT, Your Lordship, wherein in page number 43 at the end, Your Lordship. Your Lordship, at the last 2 lines, Your Lordship, we find it relevant to mention that when an order of transfer is made in bulk, it cannot be said that the department is mandated to place detailed reasons for transfer of each and every public servant provided, Your Lordship. In view of this observation made in the order, Your Lordship, the judgment of the learned single judge is liable to be set aside insofar as my transfer is concerned, Your Lordship. And the respondent number has completed the minimum period in the place, Your Lordship.
So mass transfer without reasons.
Please.
And at the instance of the paragraph 28, page 39. As could be seen from note 1, the Department of Energy and KPTCL had received representations requesting transfer orders, and request had also been received from the Chief Minister, ministers, Lok Sabha members, and the Parliament and Parliament members and legislative part, apart from specific individual requests for this transfer. So that is how the
Same approval is there, Your Lordship, but
that is how the transfer is made and without assigning the reason.
Specific reasons are not assigned one ground, my lord, and it was after the general transfer period.
General.
Pardon?
Since the transfers were effected beyond the general transfer period,
Beyond the
Lord-
general,
Please.
beyond 1 year,
beyond month of June.
beyond month of.
Transfer period is May and June. Here the impugned order was passed in the month of October. So the learned single judge was pleased to take note that in case of transfers effected after the general transfer period, specific reasons has to be assigned as per clause 7, which is not done.
As per clause.
Clause 7 of the transfer guidelines, my lord. Your lordship will find the transfer guidelines at page 126. The relevant clause, page 130 is clause 7, my lord. One
138, 126.
Please, it starts with page 126. Relevant clause 7 is at page 130.
It started which page?
Page 126, my lord, annexure R5.
That is 125,
Sorry, my lord, in my.
whatever it is, yes.
Clause 7. May I read?
Clause 7 at which page?
Page 130 of the copy served to me, my lord.
130.
The transfer should not be considered beyond the month of June.
One 120?
130 in the appeal memo served.
130, your lordship.
130.
130.
Which is clause number?
Clause 7, my lord.
7.
7. नहीं है clause 7 ही नहीं. 1 second.
The starting top portion itself, it is there.
There is no clause 7 available in my report. Proceedings of the, yes. Pages are missing in my report.
Sorry.
Let us see. Clause 7.
May I read, your lordship?
So none of these circumstances are available.
That is the finding of the learned single judge, and mainly, my lord, there is no reasoning assigned for even the office note was verified. Since there are no reasonings, clause 7 is not fulfilled, and on this ground, the learned single judge was pleased to allow the cases, my lord.
Your lordship.
Any judgment of the Supreme Court that a transfer in breach of the guidelines cannot be.
My lord, the full bench of this honorable court has held that transfer guidelines are having statutory force.
Like
SN Gangadharaya case, my lord, I don't have a,
day after tomorrow,
please,
day after tomorrow,
please.
day after tomorrow.
There are full bench has held that
You
the
give
transfer guidelines are having statutory force.
So day after tomorrow at 2:30. For
Please.
that purpose.
Please.
Yes, your lordship.
May I make one request? Monday, my lord.
Monday.
Obliged to accept.
Monday. 15 to.
December 39. Shrikant NV.
I appear for the appellant. The issue with regard to my lord, the delay, my lords, the PTCL Amendment Act, my lord, section 5 of PTCL Amendment Act, my lord. The learned single judge, my lord, had dismissed the
writ petition on the ground of delay, my lord.
What is the delay?
Delay, my lords,
9
9 years of delay.
9 years.
So dismissed.
Lords, one submission. my
We
lord.
have dismissed all matters.
Lords, in this
Bec-
case, my lord,
Because of the Dharwad bench judgment, distinguishing between the delay and laches.
my lords, here, my lords,
Distinguish between limitation and delay and laches.
Delay and latches.
Lords, my response submission is that, my lord, the grant was made in the year 1981, my lord.
Hmm.
The sale deed was executed, my lord, in the year 1997.
Hmm?
The 1997, my lords.
What?
The condition of the grant, my lords, is 15 years. Beyond 15 years, my lord, the appellant has sold the property to the fourth respondent, my lord.
But reckoned from the date of grant, it is how many years?
My lords,
51.
after the commencement of the act, my lord, as per section 4(2) of the PTCL Act, the prior permission from the deputy committee has to be obtained. That is the issue, my lords, that is the contention of the appellant here in the prior permission is not there, my lords. As per section 4(2) of the PTCL Act, my
The
lord.
ground which appears to have been weighing with the coordinate bench is that if there is a laches and delay,
Correct.
then your right to relief is lost. Correct?
Correct.
Nothing to be seen.
Not
That
para,
is the-
para 6 of the judgment of the learned single judge, my lord, not only on the ground of delay, my lord. The learned single judge has said that this grant is, there is a document of title that is given in the form of, form number 1, my lord. And it does not qualify to be a grant under, for a depressed class, my lord. That is the finding, my lord. Para 6 may kindly be seen.
Para 6.
Second sentence, my lord.
Para 6.
Page
Of
15, my
the
lords.
single
Running
judge
page
order,
number.
page 15 may kindly be seen.
If the grant of
If
certificate.
a
is
grant
issued under-
certificate is issued under form number 1, it has to be treated as a title document and the same cannot be termed as a grant to the category of depressed class.
So this
it's
is,
also for this
this is a
reason, my
grant
lord.
upon payment of price.
Please, my lord, this is a document of title, my lord, not a grant to a depressed class. Therefore, the act is not applicable in this case. That is also one of the
Yesterday
findings.
only we dictated it.
Please, PTCL Act 3B Lordship dictated yesterday, section 3.
We dismiss it. Heard learned advocate Mr. So and so for the appellant. And learned additional government advocate Mr. Harish for the respondent number 1, state and its authorities, and learned advocate
Respondent number 4.
number 4. The challenge in this appeal is addressed to judgment in order dated 22nd June 2023, passed by learned single judge, whereby the writ petition came to be dismissed. The petitioner appellant in his writ petition prayed to set aside the order dated 20th/9/22, passed by respondent 2. It was further prayed that the sale deed dated 14/9/97 was liable to be declared as, was to be 1997, was made in law. It was the next prayer to direct the respondent to release the same. paragraph. The facts shortly stated are that the petitioner applied the order, the petition applied for restoration of the land by applying under section 5 of the Karnataka Scheduled Caste and Scheduled Tribes prohibition into brigade prohibition of transfer of certain lands, bracket or Act 1978, full stop. Respondent 3 Assistant Commissioner rejected the application on the ground that the grantee had failed to substantiate that the petitioner that the land in question was a granted land. Full stop. While dismissing the petition, two grounds weighed with learned single judge. First was that the grantee had alienated the property in favor of the respondent 4, private respondent 4, under registered sale deed as back as on 23/7/1997. The petition for restoration was filed in the year 2006 before the competent authority. Application for restoration was moved in 2006 before the competent authority, which was after delay of 9 years. Full stop. Learned single judge relied on the decision of the Supreme Court in Nikanti Rama Lakshmi versus State of Karnataka, 2020 14 SCC 232, in which the law was laid down that applications for restoration of the land under section 5 of the Act filed after unreasonable delay could not be accepted. Full stop. The said decision was considered by the coordinate bench of this court in Gauramma versus so and so, which was writ appeal number so and so, decided on so and so, in light of the amendment in section 5 by amending 1978, in which decision the coordinate bench noted that though the amendment provided that no limitation would apply to invoke the provisions of the Act, a subtle distinction was made on the basis of the decision of the Supreme Court in Union of India versus N. Muruge Son, 2022 to SCC 25, to draw a fine distinction between the limitation on one hand and the delay and laches on other hand. Full stop. Delay and laches, paragraph. Delay and laches involve a culpability on part of the party. Full stop. While observing that the amendment in section 5, while noting that the challenge to the validity of, while observing that the challenge to the amendment to section 5 is a subject matter of writ petition before this court, without touching the said aspect, the court held that in cases where the applications were moved for restoration after delay and the delay was marred amenability by laches, the same such applications are liable to be dismissed. Full stop. In the present case, the delay is 9 years, could not be said to be a period which would entitle to, the delay of 9 years could be said to be unreasonable period, which would disentitle the petitioner relief. Full stop. The more weighty ground is that the land in question was not a granted land within the meaning of the definition of section 3 into bracket E of the Act. Therefore, the provisions of the Act itself could not be said to be applicable. Full stop. The approach of learned single judge and reasons supplied could be said are eminently just, proper and legal. No interference called for. The appeal is dismissed. Delay will condone. Everybody is appeared. Yeah. Third learned counsel of the respective parties, the application is filed to condone the delay of 260.
16
days.
216.
216 days, full stop. The accompanying affidavit explains the passage of time leading to delay, full stop. The grounds make out the sufficient cause, therefore delay is condoned, application is
Please.
an order in. Thereafter, said appeal was taken up for final consideration with the consent of all learned advocates. For 10 order.
So number 40,
For the
So the
Sorry.
appellant,
into three in this case, man. But there is some personal inconvenience to my senior. It's
Pardon?
not, my senior is not in town. There is a
Pardon.
death in the family of my senior. Kindly, it may be heard after 2 weeks.
After vacation.
Please, please.
Connected matter, I am the appellant. Notice may be direct to take notice, the same party, R1 to R.
Notice there is delay of 142 days.
Because
let-
already arrangement of the same order, filed by one BM Marshal, one by the KADB. I may permitted some notice to the other parties.
Notice
Already
returnable
record.
on. So notice, will issue notice?
Yes, my lord, Mr. Mitra, why can Sharma is appearing for the.
What are you saying? You will serve the notice to the others?
Yeah, Mr. Sharma is appearing already in connected matter, my lord.
Notice returnable on. When the other matter is coming?
My friend is appearing, my lord. It's already on record, my lord, connected matter.
Notice returnable on. After vacation will be 12th February. Full stop. Since the connected petition, which is writ petition number 1817 of 24 is already listed. And with the respondent appear, it will be permissible for the appellant herein to serve copy of the counsel appearing in the connected matter.
Yes.
You are there? You are accepting the notice?
Right.
Will be
I will accept notice on behalf of respondent.
paragraph. Learned advocate, Mr. So and so accept notice on behalf of
Respondent number 4, who is the appellant in the connected.
4.
Yes, ma'am.
Respondent number 4 in my, in the second matter.
Who is up?
I'm the appellant in the first matter. So I will accept notice on behalf of respondent number 4 in writ appeal 817. 817.
817, we are not issuing notice. In this,
It's
we are-
connected, but it's
No,
connected.
in the first matter, notice is already issued.
Sure, my lord.
So this is in
In
817.
358,
Yes.
817.
in eight.
40.
Government advocate for R5.
Understood. Yes. We'll take up on that.
number 41, TP Mutana.
Respond number 2's counsel. I prefer the appellant. In this case, the honorable court has already granted interim order, my lord. It posted for stay, already stay has been granted by this honorable court in this matter earlier.
Vacating
That is on 10th April 2024.
We granted, then let it go up.
My lord, one second. The question of payment of gratuity. Gratuity.
We'll consider.
My lord, is payable, my lord.
Stand over to 10th February, interim granted, order granted will continue to operate till the next.
Please.
This 42, my lord.
42,
My lord, I have filed wakalat for second respondent KHB on 25/10/2024. My name is not shown, my lord.
We'll show your name. Yes, next. On the next day, we'll show.
42, B Vachan.
42. Acha. Your name is not shown. 42. Name is not shown. Name is not shown.
Yes, my lord.
So
My
you
name is
want
not
time?
shown. On 25/10/2024, my lord, I have filed wakalat.
So you want time?
MN Ramanjaneya Gowda.
Time is not sought in this matter. He says that his name is not shown in the list. Lord,
we are ready to go on with it. Lordship, sir, kindly grant me 2 weeks' time, some personal inconvenience for my senior, because of which he is not be present.
Then it will go 11th February.
Please.
As
May I
requested
request
by
the date
learned
in-
advocate for the appellant on the ground that the learned senior advocate who will be conducting the
Early part of January.
matter has some personal difficulty. Next.
Number 43. Mr. Rajshekar S. 43.
Yes.
43, 57 and 70, my lords, two contempt petitions are also there. Notes 43, 57 and 70, my lords.
So to be taken this side or no urgency?
I know there is a delay of almost 94 days delay.
Delay is
and
also there,
proper
my lord.
explanation has not been given. It is, proper explanation has not been given, my lord.
You-
Just a delay, that's the way they have made the application. And this is a matter, my lord, it's pertaining to adult education, my lord. All the people who have, the petitioners, they are all retiring one by one, my lord. This honorable, the single bench has already verified all the records and granted the relief, my lord. This matter can be heard and decided, my lord, because they all are retiring, my lord. So if contempt is also listed before your lordship today, my lord.
The short,
Yeah,
very
serial
short
numbers.
point involved in the present case.
A
is,
very
my lord,
small point is involved, my lord, if your
whether
lordship
the
can hear the matter.
petitioners who are the, my lords, employees of NGO can be treated as, my lords, at par with, my lords, the central government employees. Is the short point involved in the present case. Lords, they have filed contempt also, my lords. So our contention is, my lords, we only give funds, my lords, central government only provides funds for them. And it is for the, my lords, respondent number 3 to pay the, my lords, allowances. As per the, my lords, the pay scale of, my lords, the central government employees. They cannot be treated as, my lords, employees of central government was our contention. Lords,
Time before vacation we proceed.
please, my lords,
We can, my lord, we can.
17th.
please. ASG also appears in this matter.
If time permits on 17th.
7 may be taken up together, my lords, contempt also, my lords.
All together.
Please.
It can be taken on,
57, 70, 96.
one submission, my lord. Instead of 17, it can be taken on 18th.
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 Let's, maybe, both the contempt also may be ordered to be tagged along with
All
this.
the matters can be taken together.
Grateful, grateful.
Serial number 79 minutes. Seek for an adjournment on the ground that translation copy has to be filed.
At the request of 79, at the request of learned advocate for the appellant who wants to file the translated copies, 10 or to 12th February.
And the
My
R3
lordship,
will be-
the item number 95.
Telling with us, sir, madam. R3 minutes is a special land acquisition officer, madam.
On that, you can do at the time of hearing.
My lordship, in the item number 95, I am from the VC. Actually, last date I requested my lordship to take up this case, and short date was given. But since my item is 95, so it has not come. So kindly give me the date of 20th of December to be taken on the top of the board, if kindly.
20th December.
At top of the board, kindly. Because the R4 is retiring in this case. It is a contempt petition.
Last day, reopening we may keep 7th January, Mr. 7th January.
My lordship.
Yes.
Serial number 45. I filed a memo for disposal of the appeal. Other side is also here for the copy. They are also agreeable to dispose of in terms of the memo. It could be disposed of not according to the contention is that award ought to have been passed by the KRDB under the new act, but they were passed under the old act. That was challenged because on the court.
Which old act?
They're not single judge, land acquisition act.
Land acquisition.
Yes, that is, the other side is also agreeable
to give the compensation under section 29(2) as a package compensation to me, because it has been given to respond number 2 also. And respond number 1 also, I'm claiming the same. They are agreeable.
So you are arrived at some settlement in black and white? You arrived at some settlement in black and white?
29(2), my lord, the package compensation is being given by the KID.
They are agreeing to your proposition?
Yes.
Who appears?
Time for the KIDB, my lord, it's appeal filed by me. My lord, because the every single judge passed the.
We'll look into it day after tomorrow. Give the, which is the number today?
45.
45.
45.
45.
Yes.
Keep it day after tomorrow at 2:30. Subject to available time, we'll dispose of.
Yes.
Give for reading. Yes.
With lordship, kindly, see the list number 2, seeking adjournment. List number 5.
$973.
Please. Council on record is not feeling well, my lord. Council on record is not well, my lord.
Council record is not available.
Not well, not well, my lord.
So when other matter, 18th it is.
18th, my lord. Connected
18th
matters.
at 2:30.
Please.
जो भी लेंगे 2:30 सेकंड बोल्ट कर लो थोड़ा कम है
The list number 2. Still number 1.
I appeal for the appellant's counsel.
Respondent.
91. Appellants are the legal representative. Appellants are the legal representatives of the purchaser, my lord. Respondent 3 was the grantee. Lord, the land 1 acre 20 guntas in survey number 24 of Basavanapura village was granted in favor of the deceased respondent number 3 on 16/3/1979. On an upset price of rupees 200. It was not a free grant, it was a grant on upset price. On 16/3/79. Lord, the grantee had sold 1 acre 20 guntas in favor of the fourth respondent on 21/3/1994. The respondent in turn had sold the said land in favor of the respondent 6 on 21/3/1996. Out of 1 acre 20 guntas, Lord, the respondent 6 had sold 9 guntas in favor of the husband of the appellant 1 and father of the appellant 2 on 2/8/1996. The proceedings was initiated in 2001, 7 years after the sale. Lord, in the same survey number, Lord, grants were made in favor of other 23 persons, including, Lord, the respondent number 3. In a similar case, one Rattamma had filed a petition application before the Assistant Commissioner seeking resumption and restoration of the granted land. Lord, that application was rejected
on the ground that it was granted an offset price of rupees 200. That was attained finality. Now, contrary to that order, now the claim made by the respondent number 3 was allowed. Deputy Commissioner has confirmed it. Lord, I have produced the order passed by the Assistant Commissioner in respect of another grantee at annexure Q. Page number 182, my lord. Page number 182. The order is relating to the, yes, my lord. Lord, the Assistant Commissioner has passed 2 conflicting orders. Assistant Commissioner, being a statutory authority, my lord, ought not to have discriminated. The impugned order is violation of Article 14.
My lord, the Assistant Commissioner, my lord, on an application from the grantee, my lord, has passed an order for restoration of the land, which order was confirmed by the Deputy Commissioner, my lord. Now the subsequent purchases have gone in appeal before the writ court. The order, an order of dismissal has been passed here, my lord. They confirm, my lord. Eventually restoration is confirmed, my lord. Now, my lord, the lordship look at the facts, my lord. The rejection is on the ground that the permission has not been obtained, my lord. It's on a slightly different footing, my lord, in this case. Please, my lord. Permission has not been obtained for alienation, but 2 alienations have taken place subsequently, my lord, starting from 1994. There has been alienation, my lord. 7 years delay is there. Has held that there is a reasonable finding, my lord.
The Supreme Court judgment, kindly see page number 32, my lord. No, my lord, Satyan's case, lordship has referred, my lord, kindly page number 32. Satyan was the Deputy Commissioner, my lord. Supreme Court. This is a granted land, my lord.
Please.
Granted land, their application was filed, sale was filed in 1996, my lord, 16/12/1996. The application was filed in 2005. And the relevant para is at 34, my lord.
So there is only solitary ground, my lord, that permission has not been obtained. That's a conversion order, my lord.
Not conversion order. 182.
197.
What is 197?
18.
Lord, 182, my lord.
No, 197. this 12th March 1979. It is a grant order.
It is a grant order. Official memorandum, my lord. 198. It was 12/3/1979.
ऐसा है.
That it's granted for upset price. It was a grant model, official memorandum issued by the deputy commissioner granting on upset price.
Encroached upon. So it is not a granted. What is the effect of it?
My lord, the same purchases, different purchases, my lord, the same survey number. This honorable court has been rejected. 14 Feb 2023, different purchasers had filed an appeal, my lord. It has been dismissed on 14 Feb 2023. The same survey number, my lord.
Purchasers had filed a
Different purchasers.
appeals
Please, they had filed an appeal, my lord,
against
against the respondents, against me, my lord. It has been dismissed.
your purchaser.
I'm grantee, my lord.
You are granting.
Yes, please.
So you are in support of this judgment.
Satyan's case, yes, please, my lord. Please.
Like,
The same subject matter, my lord, same survey number.
acha.
Please, my lord, same survey number.
24 and 25.
Supreme Court in the first place. It cannot be held application seeking resumption once held belatedly.
So then this is the trump card. This finally clinches this against you.
Yes, my lord, this order is against me, my lord.
Hmm?
But in my case, my lord,
Hmm.
the grant was on upset price. If the grant was made on upset price, not the assistant commissioner was required to hold an inquiry whether it was a grant on market value or reduced upset price or not. That has not been done. Once, if it is granted on upset price, condition cannot be imposed for non-alienation.
But then that issue will now disappear once this judgment is at the
But
instance of
that was-
purchaser, the purchaser have failed. And the things they have held finally in the favor of the grantee.
Please.
So it is
Have not filed
difficult
any
for
appeal
us to
also.
reopen the now things, even if to some extent you may be right. Give the judgment copy.
I've served. Not,
Coordinate bench has finally settled. So
Lord, another division bench of Dharwad bench.
that Harvard bench is a different now. It will not apply in this case.
Lord, in annexure Q, Lord, the assistant commissioner has passed a contrary order rejecting the claim for restoration. On the ground, it was a grant on upset price. Now, contrary to that, the application of the respondent 3 has been considered. Kindly see, my lord, annexure Q at page number 182. The relevant portion at page number 186. May I read, Lord? At 186. Paragraph 3 comes in the middle, my lord, of the page. Here I was not a party, man. Some other case. True, it is a similar case. I am pointing out the similar case. In respect of another portion of the land in same survey number. That is also 1 acre 20 guntas.
You are a purchaser.
I am the purchaser.
Purchase from Keshava,
Keshava, respondent number 6.
R. Keshava. Now this judgment has put a seal on you, which you said.
Lord, here Keshava, respondent number 6, my lord, he had formed 20 sites in this survey number out of 1 acre 20 guntas. 9 guntas was sold in favor of the petitioner, the appellant's hearing. Remaining land was formed into a sites. All the sites were sold. Purchasers, Lord, have not been made a party. They proceeded only against the respondents 4 to 6. Others have not been made a party. This land, my lord, Basunpura was included within BBMP in 2007. Earlier, it was within CMC. Taxes have been paid to earlier CMC and also subsequently from 2007, Lord, taxes have been paid to
Or
BBMP.
learned advocate, Mr. So and so, so and so. The senior advocate,
Please, my lord.
assisted by learned advocate, Mr. Senior advocate, so and so, assisted by learned advocate, so and so for the appellant. Learned additional government advocate, learned additional government with the Harish.
Respondent number 1 and
Respondent number 1 state and British. What is your good name? Learned advocate, Mr.
Rahul S. Reddy, my lord.
Rahul Reddy for responder.
Respondent number 3A to C, my lord.
Respond 3.
3A.
Original
2C.
petition. Respond 3. Respond number
3A, my lord. 2C.
3A. Respond 3. Challenge in the present writ appeal. Challenge in the present appeal. Referred under section 4 of the Karnataka High Court Act 1961 by the original petitioner is directed against judgment in order dated common judgment in order dated 23rd August 2019 of learned single judge insofar as it relates to the decision in writ petition number 65141 of 2016. The petition filed by the appellant, not a same petition filed the appellant came to be dismissed. What was prayed in the petition was to decide the order dated 15/11/2011, passed by Response number 2, the Assistant Commissioners, Bangalore. In K full stop, SC full stop, SC full stop, in case number K full stop, SC full stop, ST full stop, 62 of 2010-11, as well as order dated 29/9/16, passed by Response number 1, Deputy Commissioner. In appeal. In appeal. In appeal. Confirming the order of the Assistant Commissioner. The by said orders, the Response 1 and 2 authorities, Response 2 and 1 authorities, first 2, then 1, 2 and 1, Response number 1 authority, as well as Response 2 authority, as well as Response 1 appellate authority. Confirmed, not confirmed, invalidated the sale of land bearing survey number 24 at measuring 1 acre and 20 guthas, situated at Basavanapura village, KR Puram Hobli, Bangalore East.
Bangalore East Taluk.
Was purchased by the petitioner. The said land, petitioner appellant. The said land was stated to be initially granted on 16/3/1979 in favor of one Muni Venkatamma, who sold the entire parcel of land to one Mastan Khan, MST agent, Mastan Khan alag, separate, KHAN. By registered sale date dated 21/3/94. Said purchaser Khan in turn sold the land to one R. Keshava on 21/3/1996 by registered sale deed. Full stop. Said R. Keshava formed a layout, and out of the said layout, part of the land came to be sold, along with other persons, to the petitioner, appellant. It appears that paragraph, the original grantee filed application before the competent authority under section 4 and 5 of the Karnataka Scheduled Caste and Scheduled Tribes and to bracket prohibition of transfer of certain lands. Retiral Act 19. What is the date?
It's 78.
1978. On the ground that the land was granted land and that the sale thereof was in breach of section 4 into bracket 2 of the Act. Section 4 into bracket 2. Section 4 of the Act. Section 4 of the Act. Section 4 of the Act deals with provides for prohibition of transfer of granted lands. To treat such transfer to be null and void, to further contemplate that no right title interest shall accrue to the transferee if the granted land is sold in breach of the condition and despite prohibition. Subsection 2 of the said section provides that no person shall, after the commencement of the act, transfer or acquire by transfer any granted land without the previous permission of the government. Full stop. In the instant case, paragraph. Admittedly, the transfer of land by way of sale was on 21/3/1994 when the said Muni Venkattamma sold the property in favor of Masthan Khan. The act came into force with effect from 1/1/79. Therefore, the sale dated 21/3/94 in favor of the Masthan Khan and all subsequent sale transaction would be said to have been in violation of subsection 2 of section 4 of the act, having been executed without prior permission of the competent authority. It is on this ground that the Respond number 1 and 2 authorities invalidated the sale, which was confirmed by learned single judge. Paragraph. One of the aspect was that the application for setting aside for treating the sale null and void was filed by the grantee after 8 years. Full stop. Learned single judge dealt with the aspect whether the period of 8 years could be said to be reasonable period to permit the original grantee to make prayer under section 4 of the act, or read with section 5 of the act. Also, in this regard, learned single judge has relied on decision of the Supreme Court in Satyan, SATYN versus Deputy Commissioner and others, 2020, 14 SCC 210, in which it is held that period of 8 years could be said to be reasonable period, and the application of the grantee to under section 5 or read with section 5 would not be treated as barred by delay or laches if filed within such reasonable time. As regards the consequence of paragraph, the sale executed in breach of section 4 into bracket 2 from a learned single judge observed thus, extracting from paragraph 13, page 3, page 34. This is green, bracketed portion. Paragraph after quoting. The breach of section 4 into bracket 2 of the act is established since the sale by the original grantee, since the sale was after the coming into force of the act, the invalidation of such sale or the sale transaction becoming null and void is a statutory consequence. Learned single judge was therefore justified in upholding the orders passed by the competent authorities and dismissing the petition. Full stop. Another aspect finally works paragraph in favor of the respond number, finally works against respond number, against the petitioner, appellant. Full stop. It was pointed out by learned advocate Mr. So-and-so appearing to 3 that one of the purchaser, please, of the very land survey number 24 in the very land survey number 24 had challenged the orders passed by the competent authority before this court in writ petition number in M. Bhaskara Reddy versus Special Deputy Commissioner, which was writ appeal number 1211 of 21, decided by the coordinate bench on 14th February 2023. The controversy was controversy in that at the same compass and similar contents, full stop. The coordinate bench also relied on the decision in Satyam to hold that since the application was filed within a period of 7 years, it was within reasonable period, the judgment and order of law on a single judge was affirmed. The resumption of land was held to be rightly ordered by the Deputy Commissioner. In the aforesaid view, no case could be said, no case exists or could be demonstrated, which will require this court to interfere with the judgment and order of law in a single judge. It does not book any error. Paragraph. The writ appeal is meritless, the same is dismissed.
Second matter also same thing. Connected matter, not
Connected,
the appellant is a purchaser of a house site.
which one, which connected?
Serial number 2,
Two.
second
Appellant is purchaser.
purchaser.
outside.
House site
Same.
Same.
measuring 37.5 into 41 feet.
Site,
my lord.
right, outside.
It's a site coming within BBMP limits only.
Those, once this is hit by 4-2, or it is hit by laches in the other case, no other question can be found. Yeah, yes. Well, same order, will pass. Sorry, come with the better matter. Dismissed, both dismissed. So this is to be. I'll show you, there's some changes.
Seal number 3. Mr. Sheshadri,
I appear for respondent number 5 in this matter.
Years delay, man.
Internal page 13.
11 years.
11 years, man. 13.
Mr. Sheshadri,
1832.
Marat. 18.
18.
None appears for the petitioner in that view, in larger interest of justice, without missing the petition, stand over to 18th December 2020.
put 4 to 6 are urgent. Seal number 7. Mr. L. Srinivas Babu,
Same order.
Representing.
First line, write down first line.
May I make a-
This appeal was notified in a special board.
But
Since special board, however, none was present.
serial number
On
4, I
behalf
am for
of the
respondent. Serial number 4, my lords.
418.
4 is again 18.
7, 8 also urgent. Seal number 9. Mr. P. N. Anja Reddy. Seal number 9. Mr. P. N. Anja Reddy.
Appear for the respondent number 5, my lord.
So no, appellant is not present. Same order.
Seal number 10. Mr. Pradeep M. Seal number 10.
For appellant. 12 years delay is there.
I'm appearing for the grantee, Your Lordship. 12 years delay is there for consideration.
12 years delay is unreasonable. You're
Yes.
taken away.
Appellant's husband was died during the proceedings, sir. His LRs are brought on record during the pendency of the proceedings, Your Lordship.
Heard learned advocate Mr. So-and-so of the appellant and learned additional government advocate Mr. Harish for the respondent, state and its authorities. Referred by the original petitioners, the present appeal. Under section 4 of the Karnataka High Court Act is directed against judgment and order dated 31st May 2023. Passed in writ petition number 4434 of 4434 of 2023, whereby the petition came to be dismissed as devoid of merits. Full stop. The challenge in the petition. Challenge in the writ petition was against order dated 21/2/22 passed by respondent to deputy commissioner, whereby the deputy commissioner allowed the application filed by respondent 4 and set aside the order dated 13/5/2008 passed by the assistant commissioner, respondent 3 herein. The appellant petitioner herein paragraph is a grantee of land. The land bearing survey number
176,
176/58
please.
at measuring 30 guntas situated at Bagaluru village,
Bagaluru village.
Jala Hobli, Bengaluru North Additional Taluka, was granted to the father of the petitioner by order dated 23/9/81. The said original grantee alienated the land during his lifetime in favor of respondent 5 by registered sale deed dated 19/5/1995, who in turn sold the land in favor of respondent 6 on 31/3/2005. Full stop. The land again changed the hand and came to be sold in favor of the present respondent 4 under registered sale deed dated 24/3/2006. The paragraph, the father of the petitioner filed an application in the year 2007 seeking restoration, filed the application under section 4 and section 4 read with section 5 of the Karnataka Scheduled Caste and Scheduled Tribes into Brigade prohibition of transfer of certain lands bracket over 1978 for restoration and restitution of the land on the ground that it was a granted land. Blown a single judge relied on the decision of the Supreme Court in Nekanti Ramalakshmi versus State of Karnataka, another 2020 14 SC 232 and other decisions to hold that there is an inordinate delay in initiating the action by the grantee, and that after the delay which was of 12 years, the application for restitution of the land could not have been accepted. Full stop. So then there is a ready paragraph in other judgment I'll give. For the, I already dictated a judgment,
Please.
we'll take this. For the aforesaid reasons, no case is made out to interfere with the judgment and order on a single judge. The appeal is meritless, it is dismissed.
Seal number 11, just use for me.
Plain manner, PF paid money, PF is filed, furnishing in PF file today. PF,
Why a little louder? You've not taken lunch?
furnishing PF paid my lord today.
Yes. 25 years.
PF paid my lord today, furnishing. Process,
Little louder.
process. Process fee paid my lord today. Process fees.
Furnishing of PF. What is the matter? Say Nikanti.
Same, my lord. There is a delay of 32 years, my lord.
32 years.
32 years. From the time of the first sale.
Delay is bigger than your age.
Senior,
Delay of. So what do? You want on 18th?
senior,
Senior, 18th at 2:30. 18th of December at 2:30.
yes, ma'am.
Still there is some confusion.
Se-
Nahin? So now we take up that. Withdraw. Me one.
The 230 matters, seal number 102, Tarun Govindraj.
So
The
what is
last
it?
occasion, this.
What is the development?
My lord, the complainant is going to comply with the order. All he is seeking for is some time, my lord, since I had mentioned on the last day. He
He is going to comply.
I've already furnished the copies of the fee receipt paid and also the communication by the mother to the father.
What amount you have paid towards fees?
Your lordship, I've paid 1,71,720, one term, 1 year, the other year being
2 years,
1,91,000.
3,60,000 approximately. I'm requesting for some time. I'm filing an affidavit to that extent. I will make the payment.
When?
Sum of 60,000, my lord, I will pay at the time on or before 31st of Jan. A sum of 1,50,000 on or before 31st of March. And another sum of rupees 1,50,000 on or before 31st
Court of law,
May.
we don't say 31st Jan and 31st Feb. You full name make a 31st January. This is not your group of friends you are making it in.
No, my lord, the
So that
order of the
language,
family court.
as far as this court is concerned, don't say 31st Jan and 31st Feb and not that,
I apologize, my lord.
Yes.
31st of January, 2025.
not the court's language.
I apologize, my lord.
Yes. So when you are going to where?
A sum of rupees 60,000 if I could be
31st of
permitted. to-
January.
31st
It's
of
two
January,
lakh,
2025. A further sum of rupees 1,50,000 on 31st of March, on or before 31st of March, 2025.
I'm okay with it, your lordship, as long as the
File
payment
it.
comes through.
You are filing some affidavit.
An affidavit to that extent. I've served a copy on my line.
Agreeable?
Please,
You are concerned with your money, not the time.
Para 4.
A proposed order dated 6/12/24. A proposed order dated 6/12/2024, passed by the court. When the matter comes up for consideration today, learned advocate for the respondent husband,
Pardon, my lord. I'm for the complainant father.
complainant father. has filed an affidavit in which he has undertook to pay undertook as required in compliance with the directions of the court, to pay the fees of his daughter,
Of my daughter, please.
for the academic year 2023-24 and academic year 2024-25.
Please.
The fees are already paid by respondent mother to the extent of rupees 1,
Your Lordship, 3 lakhs,
to the extent of rupees 1,91,550 and 1,71,720 for the 2 academic years respectively. Full stop. In the affidavit today filed by the petitioner, following is stated in paragraph 4, extracting therefrom on account of some financial stress. So this will, have you got the affidavit?
I've got the affidavit.
So paragraph 4 will takes care of your grievance.
Please,
Total amount is covered.
please.
Full stop.
Your Lordship, if I may humbly submit, I've also attached 2 other uniform expenses incurred by me, which
It is not
also,
part of the direction.
it forms part of the education fees, Your Lordship, if that may be considered.
Directions are only regarding the fees,
Please, 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 please,
but you as a capacity of wife, you can certainly ask.
please. Please, please.
You pay them.
I will pay.
Yes. What is that? What is the amount towards it?
Your Lordship, it's 7,000, Your Lordship, 7,000 odd
Towards
uniform fees.
I have received receipts for rupees
the above,
2,811.
above statement on oath
Please.
shall bind the petitioner and the amount shall be paid as indicated as per the schedule of payment
Please.
mentioned in the, as per the schedule indicated in the affidavit. Full stop. Learned advocate, Miss so and so for the respondent is satisfied with
Please.
the aforesaid schedule of payment. Full stop. It is provided that if the payment is not paid and the schedule of payment is breached, the petitioner will be exposed to the aggravated form of contempt. So at this stage, learned advocate, Miss so and so, learned advocate respondent submitted that the wife has also spent rupees 7,000 towards the uniform of the child. Full stop. Learned advocate, Mr. So and so petitioner gracefully agrees to pay the said amount also.
Please.
Along with the last installment.
Along with the last installment.
Your Lordship.
So we are closing the contempt.
My lord, I had approached the court since the visitation order had been violated by the mother. I have no access to my daughter at all. 3 times I've been able to meet my daughter by way of orders of this
So
honorable.
we'll keep this alive. With this, keep the.
In the meantime, if some arrangement may be made, my lord, to comply with the order of the family court. It's a consent order that has been passed on a joint memo, my lord.
Your Lordship, the only thing I have to submit on this is, on the last occasion, the conduct of the father was also recorded by this honorable court, and the hesitance of the child in approaching the father and spending time with him was also recorded, and such reasons is also known to Your Lordships. So based on that, appropriate orders may be passed.
While the part of the obligation to be incurred by the petitioner is taken care of as above, the rest of the directions in order dated 6/12.
5th of July, 2023, my lord.
Order dated 21/10/24.
Lord, 2110 made an arrangement for one date of visitation on 25th of
Regarding-
October.
The arrangement to avail the petitioner the visitation right to meet her daughter will continue to operate in principle. The parties may meet at the same forum mall, Konakote, every Sunday, Saturday,
I'll have to seek
every
instructions on that,
Sunday,
Your Lordship.
every Sunday, both the clients are present here. Every Sunday should
Ask,
Please, we'll let you know.
just ask.
Your Lordship, Saturdays would be appropriate.
Saturday. Are they in good terms or not as per the fixation of time?
Lordship, that
At the
is,
mutually fixed, at the time which may be fixed with mutual agreement.
Saturday, I was just informed Saturday is a working day. Saturday is a working day for him. Sunday would be even a school holiday for the child as well as
Saturday evening,
client.
Saturday evening is when.
Saturday evening. Yes,
He's mentioning to me that the distance is a lot to reach there at Forum Mall. Hence, if Sunday could be permitted or not.
you decide your view.
If an order may be passed to an extent of Saturday or Sunday, subject to the convenience of the parties.
Yes, madam. May meet either Sunday or
Please.
Saturday or Sunday.
Your Lordship, Sunday until before evening, Your Lordship, because if it gets late in the evening, it will be troublesome for the child the
Either
next day,
either Saturday evening or Sunday morning,
Sunday morning,
as per the mutual convenience
please.
of the parties. At the same mall, same mall,
Same morning, please.
at
Your
the
Lordship.
same mall, namely Forum Mall, Kona and
Kunte.
Kunte. The father may interact with the daughter for an hour or up to the time when the daughter is so willing.
Please.
Full stop. It is expected that both the parties stated that in course of their meeting, they will have.
Please.
I'm grateful, my lord. Apart from this, if he may be permitted video calls for about 15 minutes twice a week, video calls for about 15 minutes twice a week, my
It
lord.
is
Apart
not,
from
it
this,
is not there in the order. Will not improve upon anything.
it is there in the order of the family court. I apologize, my lord.
We'll see next time.
Grateful,
If this fails, we'll see.
I'm grateful.
Your Lordship, I'm so sorry. This is one rectification as per the last order. It reads reimbursement of the fees for 2022, 23, 23 and 24. Rather, it's supposed to be 23, 24 and 24, 25, Your Lordship. I
That
stand,
is
The
what
same has been
indicated,
corrected in today's
23,
order.
24 and 24, 20.
please, 24, 25.
Please.
Please, grateful, Your Lordship, grateful.
Much obliged.
So we'll say that the parties have agreed to have vada pav and ice cream on that
Please.
together.
Please. Grateful.
Serial number 103 lots.
Order is
Paying for
complied.
complainant lots. They have complied with the order.
Learned advocate, Ms. So and so jointly with learned advocate, for the petitioners jointly with learned advocate, Ms. So and so, the respondent stated, jointly stated that the order under contempt is complied with. Learned advocate for the respondent files what compliance affidavit which is taken record. In the aforesaid view, nothing survives in the proceedings. Contempt petition is disposed of accordingly. Next, what was the number?
It's 103.
103. Now it is over. Now that part admits.
This is 104. So Varun, yes.
You keep whenever it is ready. In fact, we would need the Mr. Raghavan and both.
Yes, sir.
Need synopsis because of the interrupted.
But in fact, I have prepared for the benefit of the
Some
court.
linkage is.
In fact, the propositions that I gave, my lord, it is all there. But we'll file one. Yes, we will do it.
I think you have given some synopsis.
Yes, my lord, we have.
So that-
We have.
that
I given the
appellant
propositions.
has- My synopsis is now available.
Yes, now we start.
So before I come to the facts of this case, the appellant has canvassed arguments on several facts, on evidence, and attempted to point out how the learned arbitrator omitted to look at certain evidence, etc. That has been the approach of the appellant in this appeal. But before we progress to the facts and the reasoning in the award and the section 37, I would like to just spend a few minutes on what is the settled position of law as far as the scope and jurisdiction of the courts under 34 and 37 are concerned. Because once we have a perspective on that, then this court will also be enabled to see, one, to what extent this court can intervene, and two, what ought to have been the role of the section 34 court, whether it has acted appropriately or not in the settled position of law. Couple of judgments only, not too many to be looked into. My lord will just look at my synopsis, page number 11. Page 11, my lord. Fairly well-known, well-settled decisions, culminating, in fact, in a more recent judgment of the Supreme Court expressing frustration at protracted submissions in arbitration matters. This is MMTC Vedanta, 2019 4 SCC 163. This was a case of concurring orders. Respondent had come in appeal. My lord will come to page 14, ink page 14, para 10, 11, and 12, my lord. In the synopsis, my lord, I have also extracted portions of this and made references to the paragraph numbers.
Para 14.
Ink page 14, paras 10, 11, 12.
Yeah.
Page 14, para 10.
Yes.
Before proceeding further, we find it necessary to briefly revisit the existing position of law with respect to the scope of interference with an arbitral award in India, though we do not wish to burden this judgment by discussing the principles regarding the same in detail. Such interference may be undertaken in terms of section 34 or section 37 of the Arbitration and Conciliation Act 1996. While the former deals with the challenges to an arbitral award itself, the latter inter alia deals with appeals against an order made under section 34, setting aside or refusing to set aside an arbitral award. As far as section 34 is concerned, the position is well settled by now that the court does not sit in appeal over the arbitral award and may interfere on merits on the limited ground provided under section 34 2B2, that is, if the award is against the public policy of India. As per the legal position, that is, if the award is against as per the legal position clarified through decisions of this court prior to the amendments to the 1996 Act in 2015, a violation of Indian public policy in turn includes a violation of the fundamental policy of Indian law, a violation of the interest of India, conflict with justice or morality, and the existence of patent illegality in the arbitral award. Additionally, the concept of the fundamental policy of Indian law would cover compliance with statutes and judicial precedents, adopting a judicial approach, compliance with the principles of natural justice, and Wednesbury's reasonableness. Furthermore, patent illegality itself has been held to mean contravention of the substantive law of India, contravention of the 1996 Act, and contravention of the terms of the contract. It is only if one of these conditions is met that the court may interfere with an arbitral award in terms of section 34 2B2. But such interference does not entail a review of the merits of the dispute and is limited to situations where the findings of the arbitrator are arbitrary, capricious, or perverse, or when the conscience of the court is shocked, or when the illegality is not trivial but goes to the root of the matter. An arbitral award may not be interfered with if the view taken by the arbitrator is a possible view based on the facts. Let's say para 14 below. As far as interference with an order made under section 34, as per section 37 is concerned, it cannot be disputed that such interference under section 37 cannot travel beyond the restrictions laid down under section 34.
Therefore, my lord, even this court acting in under 37 does not become a full-fledged court of appeal. It is still limited jurisdiction. It still has to see whether the award is such that it shocks the conscience of the court, that the view taken by the arbitrator is just not a possible view, and only then, under the grounds available under 34(2)(b), to this court too may interfere. Section 34 court in the facts of this case thought it not necessary to interfere. Lord, at ink page 19, the second decision, 19, Dyna Technologies. These decisions were, my lord, in 2019. What I would also endeavor to show, my lord, is that in 2019-20, the Supreme Court was still generally cautioning, saying that don't interfere too much, don't interfere too much. We will see from the line of judgments coming to Konkan Railway and thereafter, that the Supreme Court has thereafter started taking a very strong view, saying, shall not interfere. In the beginning, in 2018-19, after the 2015 amendment, the Supreme Court was only cautioning, ought not to interfere, your jurisdiction is limited. But looking at the manner in which the bar was pushing the court under Section 34 and Section 37 to interfere, the Supreme Court has hardened its stand and has, in so many words, berated the bar, saying that you are converting the arbitral jurisdiction into a regular court of appeal. You should not be doing that. I'll take my lords to the line of judgments. In 2019, the Supreme Court was still saying ought not to interfere. Page 19, my lord, Dyna Technologies, this is still 2019-20 SEC 1. Here, my lord, page 30, para 24, page 30. 24 and 25 are the two relevant paragraphs. Page 30, para 24 and 25. There is no dispute that Section 34 of the Arbitration Act limits a challenge to an award only on the grounds provided therein as interpreted by various courts. We need to be cognizant of the fact that arbitral awards should not be interfered with in a casual and cavalier manner unless the court comes to a conclusion that the perversity of the award goes to the root of the matter without there being a possibility of alternative interpretation which may sustain the arbitral award. Section 34 is different in its approach and cannot be equated with a normal appellate jurisdiction. Now, this is important. The mandate under Section 34 is to respect the finality of the arbitral award and the party autonomy to get their dispute adjudicated by an alternative forum as provided under the law. If the courts were to interfere with the arbitral award in the usual course on factual aspects, then the commercial wisdom behind opting for alternate dispute resolution would stand frustrated. Moreover, umpteen number of judgments of this court have categorically held that the courts should not interfere with an award merely because an alternative view on facts and interpretation of contract exists. The courts need to be cautious and should defer to the view taken by the arbitral tribunal, even if the reasoning provided in the award is implied, unless such award portrays perversity unpardonable under Section 34 of the Arbitration Act. So the appellants endeavor to persuade this honorable court to consider an alternate view. The Supreme Court says that is not the jurisdiction of this court under Section 37. In fact, the mandate is to sustain the award. If the award is otherwise with reasons and is a possible view, there is no occasion for either the 34 court or the 37 court to interfere in the award. Now, the next decision at ink page 35, we now come to 2022. UHL Power Company Limited, 2022 4 SCC 116. Page 43, para 15, 16. Page 43, para 15, 16, and then 18. Man. Para 15. Yes. This court also accepts as correct the view expressed by the appellate court that the learned single judge committed a gross error in reappreciating the findings returned by the arbitral tribunal and taking an entirely different view in respect of the interpretation of the relevant clauses of the implementation agreement governing the parties, inasmuch as it was not open to the said court to do so in proceedings under Section 34 of the Arbitration Act by virtually acting as a court of appeal. As it is, the jurisdiction conferred on courts under Section 34 of the Arbitration Act is fairly narrow. When it comes to the scope of an appeal under Section 37 of the Arbitration Act, the jurisdiction of an appellate court in examining an order, setting aside or refusing to set aside an award is all the more circumscribed. This is now the language is getting stronger of the Supreme Court. Earlier ought not to interfere. Now in so many words says the Section 37 court's jurisdiction is all the more circumscribed, narrower than that of the Section 34 court also. Next page, my lord, para 18. It has also been held time and again by this court that if there are two plausible interpretations of the terms and conditions of the contract, then no fault can be found if the learned arbitrator proceeds to accept one interpretation as against the other. The next decision, page 48. Konkan Railway, my lord, 2023, 9 SCC 85. My lord, we'll see page 48, Konkan Railway, 2023, 9 SCC 85. I am referring to page para 19 at page 58. Para 19, page 58, 19 and then 25, my lords.
Page 58.
Page 58. Konkan Railway, 2023, 9 SCC.
Next slide.
Para 19, the court just reiterates the position of law and in 2025 further clarifies the nature of approach of the courts under Section 37. This was a case, my lord, Konkan Railway was a case where the arbitral award was confirmed by the Section 34 court. Section 37 court intervened in concurrent findings. The Supreme Court said, no, you ought not to. Judgment begins at 48. Oh, he does not have that. Yes.
Which paragraph?
Well, para 19 at page 58. Para 19. 19 at page 58. Well, 19, it's just the position of law is stated, then I'll take my lords to 25. Therefore, the scope of jurisdiction under Section 34 and Section 37 of the Act is not akin to normal appellate jurisdiction. It is well settled that courts ought not to interfere with the arbitral award in a casual and cavalier manner. The mere possibility of an alternate view on facts or interpretation of the contract does not entitle courts to reverse the findings of the arbitral tribunal. The court repeated Dyna Technologies. Then at para 25, the court sharpened its language. Page 62. Because this is what the appellant is attempting to do, saying that the entire contract as a whole must be given effect to, every clause must be looked at. The learned arbitrator has omitted to consider certain clauses. The Supreme Court deals with that argument also. At para 25. The principle of interpretation of contracts adopted by the division bench of the High Court, that when two constructions are possible, then courts must prefer the one which gives effect and voice to all clauses does not have absolute application, which is the case being sought to be made out by the appellant here. That this clause was not looked at, that clause was not looked at, this clause was subject to that clause. That is the argument of the appellant. The court says no. The learned arbitrator has understood the contract in a particular manner. If that understanding is not untenable, it does not shock the conscience of the court, is a possible view, there is no occasion for this, for the subsequent courts in 34 or in 37 to intervene. And this is a principle that is often urged by the losing party, saying one clause was not looked at, some other clause was not looked at. Therefore, the court says, principle of interpretation of contracts adopted by the division bench of the High Court, that when two constructions are possible, then courts must prefer the one which gives effect and voice to all clauses, does not have absolute application. The said interpretation is subject to the jurisdiction which a court is called upon to exercise. While exercising jurisdiction under Section 37 of the Act, the court is concerned about the jurisdiction that the Section 34 exercise, while Section 34 court exercise, while considering the challenge to the arbitral award. The jurisdiction under Section 34 of the Act is exercised only to see if the arbitral tribunal's view is perverse or manifestly arbitrary. Accordingly, the question of reinterpreting the contract on an alternative view does not arise. If this is the principle applicable to exercise of jurisdiction under Section 34 of the Act, a division bench exercising jurisdiction under Section 37 of the Act cannot reverse an award, much less the decision of a single judge, on the ground that they have not given effect and voice to all clauses of the contract. This is where the division bench of the High Court committed an error in reinterpreting a contractual clause while exercising jurisdiction under Section 37 of the Act. You see, my lords, this is what I said. In 2019, the court was still saying, ought not to interfere, respect the award, etc. Now the language is in no uncertain terms. If the award is tenable, if the interpretation is tenable, this court shall not interfere. That is the language being used by the Supreme Court. Lord, page 68, the next decision, where the Supreme Court now openly expresses irritation at the manner in which arguments are sought to be made out to challenge arbitral awards which have subsequently been confirmed. Bombay Slum Redevelopment Corporation, my lord, page 68, a very recent decision of July 2024, just a few months ago. Lord, at page 84, para 26. Again, initially, the position of law is set out, and then the Honorable Supreme Court sets out its views in the matter. Page 84, para 26. My lord, has para 26.
Length of the arguments of both of you is an indication that the disposal by the court below was a summary disposal. And that is mentioned in, go to page 29.
I'll take my lord to that relevant paragraph. My lord has correctly got it. My lord has rightly got it. That where in fact, brevity is now seen to be an offense.
Sir, Raghavan says that this is a summary disposal without going into all these aspects.
That's right. In fact, that is what the Supreme Court says. Brevity should be appreciated. Merely because the Section 34 court has been brief in its review does not mean it is wrong. What still ought to be looked at is whether the award is questionable. If the award is correct, if the award is not bereft of reasons, if the award is all right, and the 34 court says, in fact, my lord, as soon as the appellant had started, my lord, it fell from this court, from the bench. And in fact, I looked for that proposition and I brought case laws. Where the appellate court is agreeing with the trial court, reasons need not be set out, is what fell from the court. And I said, that makes sense. And I looked up the judgment. The Supreme Court has said exactly the same thing, that where the appellate court is agreeing with the impugned judgment, no reasons need to be set out. If the judgment under challenge is all right, I agree with it. I don't need to restate the evidence, restate the reasons and say, in this aspect, I agree. In this aspect, I find no fault. In that aspect, I agree. It is not an exercise which is necessary, is what the Supreme Court says. And this is where the Supreme Court, in this matter, the Supreme Court expressed irritation saying, why do you drag and pull on with these matters? If the arbitral award is tenable, there ends the matter, thou shalt not interfere. But para 26 at ink page 84, and then I'll take my lord to the relevant paragraphs where the Supreme Court has something to say about the manner in which arguments are canvassed. The jurisdiction of the appellate court dealing with an appeal under section 37 against the judgment in a petition under 34 is more constrained than the jurisdiction of the court dealing with a petition under 34. Began earlier by saying it is akin, it is similar. Now the Supreme Court says enough. Even that is no longer similar. If the award is all right, 34 court has confirmed the award.
Where it is said similar?
Well, in the beginning, both are similar. In the beginning, in 2019, 34, 37, more or less the same ground. Well, we'll do that. My lord. Deliberately, my lord, I've chosen this line of decisions to show how the Supreme Court has clarified the position from time to time.
Just for academic.
No problem. My lord, ink page 15, I'm back to MMTC in 2019. Ink page 15, the grounds are the same as what the Supreme Court had said then. Ink page 15, para 14, as far as interference with an award made under section 34, as per section 37 is concerned, it cannot be disputed that such interference under 37 cannot travel beyond the restrictions laid down in 34. And in the next decision also, at page 30, the same approach, that 37 don't go beyond 34. What 34 court can do, only that much the 37 court can do. As time progressed, the Supreme Court noticed that even that does not seem to be helping. So in so many words, the Supreme Court is now saying that 34 court has done its job, 37 court shall not interfere. Your jurisdiction with respect is far more circumscribed than under 34. But I was reading at page 84, para 26. Then, my lord, at page 88, page 88, para 34, 35, 36. These now clearly set out the guideline on what arguments can be canvassed, ought to be canvassed, and how the court should deal with it, particularly in concurrent findings.
Paragraph.
Page 88, para 34, 35, 36.
Please see 29 also, my lord.
Of course, my lord, I'll read my, since my lord, I'll read 20.
Somebody dispute.
There may be exceptional cases, remand.
Sir,
No,
it's
say-
not just summary exposure.
His lordship, as Chief Justice of this court, rendered the judgment.
Yes, my lord. It is not mere
Lordship
summary
sitting in Supreme Court.
without
now
consideration.
Said this, in sitting as Chief Justice of this honorable court, my lord, his lordship rendered the judgment.
Yes. It is not merely summary disposal. I will read that.
You cited first.
Yes, sir. Yes,
Sir,
yes, yes.
Warsaw Engineers.
Warsaw Engineers.
But again,
Yes.
his lordship's views then have evolved over a period of time. At that point of time, his lordship had held that, yes, there should be every ground must be considered. As time has progressed, his lordship is now saying that enough, that doesn't seem to be helping the position now. In fact, I come to those. Since my learned friend pointed out, my lord, in 29 also, summary disposal of a petition under 34 of the Arbitration Act is made without consideration on merits. And we'll come. I'll take my lord to the 34 court decision also. My lord, I was at ink page 88, para 34. before we part with the judgment, we must record some serious concerns. My lord, this is the same, His Lordship under Warsaw had said every ground must be considered. Now His Lordship is expressing views which have evolved over a period of time. And now the Supreme Court says, before we part with the judgment, we must record some serious concerns based on our judicial experience. Case after case, we find that the arbitral proceedings have become synonymous with very bulky pleadings and evidence and very long, time-consuming submissions, leading to very lengthy awards. Moreover, there is a tendency to rely upon a large number of precedents, relevant or irrelevant. The result of all this is that we have very long hearings before the courts in section 34 and 37 proceedings. By way of illustration, we are referring to the factual aspects of the present case. The award runs into 139 pages. The petition under section 34 of the Arbitration Act runs into 93 pages and incorporates 151 grounds. The judgment of the learned single judge dealing with the petition under 34 consists of 101 pages. One of the contributing factors is that more than 35 decisions were relied upon by the parties before the learned single judge. On the same point, multiple judgments have been cited taking similar views. As per the practice in the High Court of Judicature at Bombay, a memorandum of appeal under section 34 of the Arbitration Act does not contain the facts, but only grounds of challenge. And it goes on to say so. Hello, para 36. In many cases, the proceedings under section 34 and 37 are being treated as if the same are appeals under section 96 CPC. When members of the bar take up so many grounds in petitions under section 34, which are not covered by section 34, there is a tendency to urge all those grounds which are not available in law and waste the court's time. The time of our courts is precious, considering the huge pendency. This is happening in a large number of cases. All this makes the arbitral procedure inefficient and unfair. It is high time that the members of the bar show restraint by incorporating only legally permissible grounds in petitions under section 34 and the appeals under section 37. Everyone associated with arbitral proceedings must remember that brevity will make the arbitral proceedings and the proceedings under section 34 and 37 more effective. All that we say is that all the stakeholders need to introspect. Otherwise, the very object of adopting the Retiral model will be frustrated. We are not called upon to, that is on the costs. My lord, here, my lord, now His Lordship is saying brevity is the essence. That there is no necessity for us to go on repeating arguments, repeating evidence and saying, yes, I agree or I disagree. But one more decision on this point. At ink page 90, (2024) 6 SCC 809, National Highways Authority. My lord, at page 95, in terms of contract, my lord, what the Supreme Court had said, at page 95, at the top, it's a portion of para 10, but I'll read only from the beginning at page 95. Arbitral tribunal must decide in accordance with the terms of the contract. But if an arbitrator construes a term of the contract in a reasonable manner, it will not mean that the award can be set aside on this ground. It is further observed and held that the construction of the terms of a contract is primarily for an arbitrator to decide, unless the arbitrator construes a contract in such a way that it could be said to be something that no fair-minded or reasonable person could do. It is further observed by this court in the aforesaid decision in para 33 that when a court is applying the public policy test to an arbitration award, it does not act as a court of appeal, and consequently, errors of fact cannot be corrected. A possible view by the arbitrator on facts has necessarily to pass muster, as the arbitrator is the ultimate master of the quantity and quality of evidence to be relied upon when he delivers his arbitral award. It is further observed that thus an award based on little evidence or on evidence which does not measure up in quality to a trained legal mind would not be held to be invalid on this score. So long as it is a possible view, do not interfere. Respect party autonomy. The parties have chosen the arbitral tribunal. It is for them to abide by the terms of the contract, unless it is such that it shocks the conscience of the court. This, my lord, is a summary of the position of law as it stands.
In order to substantiate these legal propositions from facts, we have to demonstrate that they are liable to pay the amount mentioned in the settlement.
That's it. I'll take, my lord. Just two more decisions, my lord, on the
which they are disputing from your own claim state.
I will demonstrate, my lord. It is not that there has been any approbation or reprobation of
even a shade that their liability arises, at least to the extent of settlement amount. Then you may be very stronger in your,
Certainly, my lord.
you are strong but stronger in.
My lord, I am grateful. I am grateful, my lord.
Not expressing any opinion, therefore I am
I am
saying.
grateful. I am grateful. My lord, I have explicitly in so many words said that the claim that I have urged before the tribunal arises out of the settlement agreement. I have not for a moment said, keep aside the settlement agreement. I want to have my cake and eat it too, which is what the appellant's case is. That the claimant before the arbitral tribunal went before the tribunal, give me the settlement agreement, give me beyond that also. That is not my case. My case is completely limited, absolutely. We entered into a settlement agreement, abide by the settlement agreement, give me what is under the settlement agreement. What I have subsequently and separately asked for is by way of damages, for which I had to lead evidence to say that I got induced into giving up a larger claim that you give me by way of evidence, by way of damages. I was obviously not able to do so, and I did not even lead any evidence. I had no evidence to that account. The Honorable Tribunal has dismissed that portion of my claim. I am not in appeal before this court saying that no, the Arbitral Tribunal ought to have done that also. My case before the tribunal was, in so many words, from the very beginning, there is a settlement award that is for 23. In fact, I said 23 crores is what they have promised me, regardless of what amount they have received from that government department, NILET. Regardless of that, I am entitled to 23 crores. They have to give me 23 crores. The arbitral tribunal very fairly has said, if 17 has come, 17 is available for distribution. Your claim for 23 is also not acceptable.
Damages, claim of damages.
Separately.
Is an arbitrable dispute or is a
That issue was, well, that was there as a claim. It was neither strongly pursued, nor was any evidence led, nor any arguments made. The tribunal also summarily just refused that claim.
No, according to you, that claim can be adjudicated by the arbitrator or some different forum will be required?
My lord, damages claim can be urged before an arbitrator. It is an arbitrary dispute.
It is arbitrable dispute.
It is an arbitrable dispute.
Damages also.
Damages also is an arbitrary. If I have a claim in damages, it is an arbitrary. It is not a claim in rem. Basically, going by the law as it stands, claim Booz Allen, Hamilton, a claim in rem cannot be. Divorce cases, criminal cases can't be urged. But otherwise, a claim arising out of contract, including specific performance and in the alternative damages, both can be urged before an arbitral tribunal. That position is more or less settled now since 2013. Well, just two more and then I'll take my lord to the facts.
We'll continue up to 4:30.
Good. Tomorrow, day after.
No, we'll come up to
No,
4:30.
not tomorrow. The day after tomorrow. Tomorrow is.
Day after two. So day after.
Oh, continue till 4:30, my lord, sir. Well, what I'll do is I'll finish the position of law before we start with the facts. The facts we can start on the next hearing. So, my lord, these are the decisions on the position of law as far as the scope and jurisdiction of courts under 34 and 37 are concerned. 34 strictly on grounds available under the Act. 37, initially the Supreme Court said more or less similar to 34. You're not a court of appeal, don't interfere. As time progressed and the Supreme Court noticed that the bar is urging so many grounds and everything is being pushed, the Supreme Court has then sharpened its language and said, no, if there is nothing wrong with the award, you shall not interfere. There is no cause, no reason for you to interfere is how the law as it stands today is the position as it emerges from this case was. Well, the proposition that much has been said about Section 34 court. In fact, the last decision, the Supreme Court also said brevity is better. You should not be very lengthy in your explanation, either in submissions or in judgment. Section 34 court has exactly been that. And that seems to be a fault on the part of the Section 34 court. That the Section 34 court has erred. Section 34 court, in fact, has looked at the grounds and said, this is what the award says. No reason to interfere. There ends the matter. The Section 34 court need not then say, you are saying this. This is what the arbitral award said. Therefore, I disagree with you. Next, you are saying this. There are 57 grounds. Unlike what the position was earlier under Warsaw, the position has evolved. There could be judgment saying a particular thing at one point in time. But if the position of law evolves over a period of time, then we don't look at the earlier decision. We look at decisions as they stand today. And more so, as Mr. Raghavan pointed, it's the same his lordship. Then that was a view.
notice, and his lordship says so in so many words, going by our judicial experience. What this court, my lord, 10 years ago, keeping in mind social issues, social values, may have said something. Today, times change. The bar does not seem to be learning from these principles. Therefore, don't interfere if there is no cause for it. In page 99, on the proposition that where the appellate court agrees with the trial court, there is no need to set out reasons. Mere lack of reasons does not ipso facto mean that the judgment is wrong. Where the judgment agrees with the judgment of the appellate court is agreeing with the trial court, mere lack of reasons ipso facto does not mean that it is a bad judgment. Look at para 13 at ink page 105. At the bottom, page 105. Para 13.
Yes.
The trial court, as we have already observed, on a consideration of the entire evidence and the subsequent conduct of the parties, came to the conclusion that there was no severance of so-and-so from his uncle. And with that view, the High Court agreed. It is true that the High Court did not enter upon a reappraisal of the evidence, but it generally approved of the reasons adduced by the trial court in support of its conclusion. We are unable to hold that the learned judges of the High Court did not, as it is contended before us, consider the evidence. It is not the duty of the appellate court, when it agrees with the view of the trial court on the evidence, either to restate the effect of the evidence or to reiterate the reasons given by the trial court. Expression of general agreement with reasons given by the court decision of which is under appeal would ordinarily suffice. This fell from my lord. And I heard that and said, there will be some decisions to support this. This is what my lord observed in the beginning on that day. And in fact, more recently also, at page 110, in 2016, the Supreme Court reiterated the same position. Page 110. 2017 to SCC 415. But at para 14, ink page 119. Page 119, para 14. The points which arise. 119, para 14. The points which arise for determination by a court of first appeal must cover all important questions involved in the case, and they should not be general and vague. But these are still in the realm of CPC appeals. Even though the appellate court would be justified in taking a different view on question of fact, that should be done after adverting to the reasons given by the trial judge in arriving at the finding in question. And these are the important ones. When the appellate court agrees with the views of the trial court on evidence, it need not restate effect of evidence or reiterate reasons given by the trial court. Expression of general agreement with reasons given by the trial court would ordinarily suffice. When the first appellate court reverses the findings of the trial court, it must record findings in clear terms explaining how the reasoning of the trial court is erroneous. Where erroneous, you set out your reasons. Where you're agreeing, you don't have to restate everything. This is exactly what the Section 34 court has done. And that is what the Supreme Court is also now saying. You must be brief in your submissions and in your decisions. I'll take my lord through the facts very briefly, my lord. Mr. Raghavan has taken us all through the agreements and all. I will not spend too much time on the next date.
Yeah.
And then I will take my lord through the award.
Can I request, my lord, subject to convenience of the court on 17th, if it is possible? My learned friend, convenience of my learned friend and your lordship's.
Don't stretch beyond.
17th afternoon will finish. 17th afternoon will finish.
Don't stretch beyond vacation.
No,
my lord. I will try and finish on 17th. It's a subject to court timing, maybe one more hearing, but not more. Grateful.
Keep skipping.
My lord, I'm just told, my lord, some other courts have already fixed at 2:30 on 17th. Some embarrassment I'll face on 17th. 18th or 19th, my lord, subject to my learned friends.
What is?
18th, I will. 18th, 16, or I'll, 18th, madam.
My learned friend can do it, but my presence may be excused on 18th.
My lord, I finish on 16th, my learned friend can come on 17th.
No, 17th, the matter is fixed.
My lord, I have got some matters fixed at 2:30.
You have got.
I have got some 2:30 matters fixed.
So you can sound 16.
16th, I can.
16th, my learned friend can, if you 17th, I'll come and reply for a few
Fair.
minutes, my lord. Yes.
Fair.
Very well. Great. Great.
Bill number 81. 81, the Saravana, yes.
Same matter, my lords. They are not appearing at all. There is a court order dated 18/4, my lords. There is supposed to be a payment of 4 crores. They are not making at all.
What is the matter?
Lords, it's a home bias, my lords. There are more than 25, 30 execution orders given by RERA. After that, writ petition, the Honorable Court has directed them to pay or they implement the orders. There is a default of more than 40 crores, my lords, in these connected petitions. I filed a I for the arrest of the, because they have filed a affidavit also, my lords. The accused, who is the builder, has filed a affidavit before this court.
Contempt petition as well as the writ appeal, both are notified together. Since Honorary Advocate Mr. So and so for the complainant.
Complainant.
Found urgency. Full stop. The cases have been repeated on the board and are also notified specially at the request of the council, who is urging urgency in the board at 2:30. Full stop. However, the matters are not being, matters could not be proceeded with since learned advocate, the appellant has been since on all occasions, the presence of learned advocate to the appellant was awaited in vain. Full stop. As a last chance, the contempt petition and the appeal is directed to be listed at 2:30 on day after 12th of December. First of learned advocate Mr. So and so. Now intimate is counted.
Please, please.
Bill number 106. The Sampath book.
But there is a office objection regarding maintainability of the appeal. But I have filed a petition before the Commercial Court, Mysuru, under Section 9. But the Honorable Court has, it was a petition for interim protection under Section 9, not to invoke the bank guarantee pursuant to termination of the contract. But
Which order is passed?
But the court has not passed any order, but they have only issued notice on my petition. But
Then
that's why, section,
this order is challenged.
please, page 136. It is the printout from
133,
36,
36.
Commercial arbitration application was filed before the Commercial Court, Mysuru, Court has reserved it for 27/11, my lord. It was posted for orders, and it was next taken on 28/11, and thereafter on 4/12, my lord. And on 4/12, my lord, court has passed in order to issue notice. That is the only order made. My lord, in respect of this, my lord, your lordship may kindly see section 37 of Arbitration and Conciliation Act. Section 37.
No, this appeal before the district court is against which order?
My lord, this is this petition is seeking an interim order of protection, not to invoke the bank guarantee, which was,
Section 9 application
please, man, section 9 application
for the district court.
before the district court. And
Your application, no.
It is his.
By you,
myself, petitioner has filed the petition before
in
Sec-
which notice is issued.
in respect of which notice is issued. Interim relief is not granted.
What relief you are seeking?
Well, stay of annexure J, my lord, that is invocation of bank guarantee to be restrained pursuant to, the contract is not in force. It was expired by efflux of time on 31/5/2024.
31,
31/5/2024.
it expires.
My lord, it expires. Agreement expires.
Agreement expires.
Yes, my lord. The respondent issued termination notice on 25/11/2024.
So
After-
where is the bank guarantee?
Please, annexure J, my lord, is the bank guarantee. Page 130, my lord. But this bank guarantee is renewed bank guarantee issued on 28/10/2024, and it will be having its validity up to 2025.
It has no reference to the original contract at all.
But there is a reference to original contract. It is drawn in favor of.
You know that bank guarantee is a separate contract.
But this is a performance guarantee in the form of a bank
It
guarantee.
is not reflected, that is.
Well, it is there, reference is there, my lord. In respect of, it is drawn in favor of the railways for
There is no order which you can challenge, Mr.
but the section 37, my lord, speaks that a refusal to grant any measure under section 9 is also appealable under section 37.
So there is no measure reason.
Refusal also, my lord. Your lordship may kindly, notwithstanding anything.
There is no refusal. That is exactly what we are saying. Where is that?
But-
Express, there is no express refusal.
express, that's what, my lord, now, by the time notice goes and comes back, my lord, they will encash the bank guarantee. This petition under section 9 itself will become infructuous. That is the difficulty, my lord. Section 9, your lordship may kindly see, and section 37, your lordship may kindly see for a moment.
Where is that notice in order? Yes. What
Issue
is-
notice is the
what
only
is-
order passed by the trial court. Page 136, only notice has been ordered by the trial court.
By filing this, what is this company appeal?
Commercial appeal, commercial arbitration appeal,
Petition.
commercial arbitration application, that is the nomenclature of petition.
COMAP, what is that?
COMAP, present,
Here,
it is commercial arbitration petition.
commercial arbitration, full stop. So commercial arbitration petition, 534. How learned advocate, Mr. So and so, so and so. So they have terminated the contract.
Please, but they have terminated the contract on 25/11 after the expiry of the contract period.
And the, otherwise this guarantee is valid till
But till it is valid up to May 2025.
29/5/2020.
115.
29/5/2025.
29,
29.
29. Third learned advocate, Ms. So and so, so and so. The prayer in this petition is for passing interim order to restrain the respondents from encashing the 4 months bank guarantee bearing BG number 13951 BG 129897. So get exit number from page 15, dated 30th 30/11/22. Pending disposal of the,
No, extended date may also be referred.
which is extended up to 28/10 to 24. From a pending disposal of the claims for the arbitral tribunal. The respondent has, it is submitted that the respondent has terminated the agreement on 31/5/24. It was further submitted that the bank guarantee was a performance guarantee. In relation to the, you are there?
For
What do you have to
respondent number 1 to 3, my lords. I appear for the respondent 1 to 3, my lords.
Who are 1 to 3?
Railway department.
Railways.
Gen-
Railway, my lords. The first respondent is the
Divisional railway manager,
railway
You are-
manager, and
You are going to encash.
Yes.
the-
I'll engage senior counsel in this. I'll engage the ASG. my lords.
Then we are issuing notice and
Please.
passing some order. Respondent have terminated the agreement in question dated 31/5/20 on 31/5/24. It was submitted on behalf of the petitioner that bank guarantee relates to the said agreement. It was therefore apprehended that the respondent may encash
please.
the bank guarantee. Full stop. The petitioner has filed an application under section 9 of the Arbitration and Conciliation Act 1996, seeking interim measure, inter-alia, to restrain the respondent from encashing the bank guarantee. However, in the same proceedings, which are what is that nomenclature? commercial arbitration application. Commercial arbitration application before the trial court, before the district and session judge Mysuru. From only notice came to BC on 4/12/24. Full stop. In view of the apprehension that if any interim order is not passed, and since the arbitration application is kept only at the notice stage by the court below, and in the meantime, if the bank guarantee is invoked from an irreversible situation would arise for the petitioner herein, and that he would suffer irreparable injury. Full stop. In the circumstances, paragraph, notice returnable on for the time being 19th of December. By way of interim protection, it is directed that if the bank guarantee has not been so far invoked, status quo shall be maintained. It is further directed that notwithstanding the termination of the contract, the bank guarantee shall continue to remain valid as given by the present petitioner in favor of the respondent. Please. We are protected. On that day, we propose to dispose of. Please. We have some thinking in mind, subject to what you submit. Or
Serial number 107, my lords.
one by one, yes.
Serial number 107, the matter pertains to the high security number plate.
Pardon?
Lordship may kindly fix a date and extend the interim order.
107.
107.
So what is it about?
It's a high security number plate matter. Number plate, high security.
Number plate.
Number
This is to
plates.
be disposed of. This is
Lordship may have it day after tomorrow. my-
in terms of the interim order.
Yes, Lordship may have it day after tomorrow, my lord.
That is what suggested by somebody.
That is, my lord, what they suggested.
No, my lord, the land advocate general had suggested, my lord.
Because what will happen is, then, my lord, there will not be any pressure to fix it will be contrary to the judgment of the Honorable Supreme Court. 4 judgments, I'll just point out.
Lord, all these appeals arise out of an interim order passed by the learned single judge. The learned advocate general on the last date of hearing suggested let the matter be heard finally by the learned
So
single.
everybody is addendum in that, right?
No, my lord.
my lord. I'm up for
Or like, when shall we keep?
Yeah, my
13th,
lord.
Jan 20th.
13th or 12th or beyond,
13th.
whatever.
All right.
13th of January.
13th.
Jan 20th. Request for 20th.
First week of January, my lords.
So, I am
Week of
ready
January.
any day.
First week of January.
First week of January, 9th of January.
My lord, serial number one. Can it be on 20th? Can it be on 20th?
20th,
January 20th.
20th,
Because there's some holidays in between, my lord.
yes.
Lord, we are ready to make the submission, my lord, at the earliest possible date. Leave to lordship, my lord.
Or an earlier.
Learned advocate general will be making the
9th
submission.
January.
Or January 3rd also is okay by now.
January
But
3rd
both
is
of
not
us-
the sitting.
Both of us will come.
Third is a holiday.
You sit-
Holidays.
You can sit here and.
With your lordship's kind leave, my lord.
Whenever you want, will.
Please.
Lord,
With
the
your lordship's kind leave.
interim
Let
order.
us see, let us keep it on 17th for time. We'll see if it is possible to find out something. Then we'll adjourn.
17th of,
Anything?
17th.
With your
January.
lordship's kind
No,
leave.
My lord,
No, 17th December.
interim order.
Serial number 108, my lords. My lords, may I make a mention, my lords? Serial number 108, my lords. It was posted yesterday, my lords. It was posted today for the reason, my lords. A writ appeal would become infructuous, my lords. This is a employee of B group who comes and claims a position of C group, and he enjoys the benefits of B group and says that, but I should not be disturbed for 4 years. Lords, kindly, any date, my lords.
After vacation.
My lords, my
Appellant has not drawn salary for 9 months, my lords. That is the difficulty, my lords.
Immediately after. Eighth of that.
This month, my lords, any date, this month, my lords.
It will not be possible. We keep it on eight. Let us see 18th. Time permits will take up.
Fine, my lords.
My lord, serial number
This month, my lords,
56, my
next
lord.
week, any date, my lords.
Serial
Yes.
number 56.
52,
56, my lord.
56, yes.
My lord, this is the matter which your lordship said, my lord, heard on a few times contempt where, in fact, your lordships had directed them. Your lordship's order, my lord, has been violated. First, they said review petition. My lord, then they went to the Honorable Supreme Court. My lord, Supreme Court in the appeal filed by the government has given us protection. Though they specifically sought for stay of the content, my lord, no interim order has been given. My lord, may I request your lordships to have it on 18th, my lord. 5 times, my lord, for non-compliance it has come. My lord.
It will not be possible, Mr. Ramsar, 18th.
8, my lord, any shorter 8, 9. 9, my lord, because your lordships, in fact, had such.
9th January.
Please.
107 interim order may be extended.
It will be extended.
Oh, my lords.
Not urgent is fine.
Not right.
Serial number 47. Huh? Serial number 47. Mention ಆಗಿಲ್ಲ. 104 ಕರೆದ್ರು 106 ಕರೆದ್ರು. ಎಲ್ಲ date, you get the dates.
So 94.
Yes, wherever interim order is extended till next date, it will be extended. ಅರ್ಜೆನ್ಸಿ ಯಾವ್ದು ಪ್ಲೀಡ್ ಮಾಡಿಲ್ಲ. ಸರಿ, ಅದಕ್ಕೆ ಡೇಟ್ ಏನಾದ್ರು ಕೊಡ್ತೀರಾ? ಡೇಟ್ ಅಪ್ಡೇಟ್ ಮಾಡಿದ್ವಿ. ಸರ್ ಎಲ್ಲ ಡೇಟ್ ಅಪ್ಡೇಟ್ ಎಲ್ಲ ಯಾವ್ದು ಈ ಮಂತ್ ಅಲ್ಲಿ ಯಾವ್ದು ಇಲ್ಲ. ಈ ಮಂತ್ ಅಲ್ಲ, ಅದಕ್ಕೆ ನಾನು ಅರ್ಲಿಯಸ್ಟ್ ಪಾಸಿಬಲ್ ಅಂದೆ. ಪಾಸಿಬಲ್ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಜಾನ್ವರಿ ಅಲ್ಲ, ನಾನು ಜಾನ್ವರಿ ಕೇಳ್ತೀನಿ.
ಸರ್ ನೆಕ್ಸ್ಟ್ ಒನ್ ಜಾನ್ ಫಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಮಾಡಿದ್ರು.
ಸರ್ 108 ಯಾವತ್ತು? 108 ಯಾವತ್ತು? 94 serial number 46 rejection matter.
ಗೊತ್ತಿಲ್ಲ ಸರ್ ಅದಕ್ಕೆ. ಯೂಟ್ಯೂಬ್ ಅಲ್ಲಿ
Serial number 107, 17 time
January ಬರುತ್ತೆ.
time in 6:30.
ಮೇಡಮ್ 75 ಸೀರಿಯಲ್ ನಂಬರ್ 75 ರೀಚ್ ಆಗಿದೆಯಾ? ಓಕೆ.
Sir, hello. Excuse me, sir.